Hello, everybody. Hi. Sorry, I ran a little behind here. We're going to do day 4 of Michael Amiott. We're going to get this out of the way here, guys. We are going to get back to him testifying. If you guys remember, he is the police officer here in Euclid, Ohio. He's accused of beating the crap out of a guy. And, hell does that mean? Oh, yeah, that's a weird email. That's weird. All right. Anyway, this is going to be in day 4. So here we go. Just remember, there's the issue. What is this? Is this police brutality? What's this guy doing police work? Let you decide. Tuned him up, Skell. Yeah. I sound nasally. Hold on. Is that better? Maybe we can do that now. Nate says, so many greens, I feel unsafe. That's the point. That's the point. Oh, hold on. What do we got? We got doggos. Aw. All right. Well, here we go. You guys remember, he had been testifying, but we were, there was a bit of a break that was being taken. So here we go. You guys remember, Cross was going a little rough for Michael Amiott. But the prosecutor himself was kind of like doing that disjointed attack thing, and it was making it hard to figure out where he was going to. But here we go. Here is the rest of it.
Jurors are prepared to be here till at least 5, so be prepared. We'll be in recess. Your testimony. I'm just reading that. During the earlier testimony, we played a part of the video, and I asked you if you heard and saw Officer Gilmore pat you on the shoulder and say, "You okay?" And you said, "I'm fine." Remember that testimony?
That's correct.
I'm going to play that again, and I'm going to ask you if you hear Gilmore say, "I got back up on the way. You okay?" And then you respond, "I'm fine." So the question is, do, okay? And for the record, I'm going to play the video at 10:26:43, and I think it happens at 10:26:50-ish, okay? Did you hear that?
I do.
And isn't it true that on the video, in the sequence of events, you're throwing a barrage of punches at Richard Hubbard. Gilmore is behind you, and as soon as you finish with that barrage of punches, he gets up and says that. Is that how it played out?
That appears correct, yes.
And
That appears correct. Oh.
you indicated in your report, did you not, that you noticed a, quote, strong odor of raw marijuana coming from the vehicle, correct?
Correct.
Is an odor of raw marijuana different than an odor of burnt marijuana?
Correct.
You're trained in that to that degree, correct?
Correct.
And so if I understand correctly, raw marijuana is unsmoked marijuana in its raw form, right?
Correct.
And if a collection of raw marijuana, let's just say the size of a softball, just for the biggest example. You have a collection of marijuana the size of a softball, and it's in like a baggie. Would you smell a strong odor or not?
It depends.
Okay. Let's say that that collection of marijuana is laying open to the elements on the dashboard of the car, and you go up to the car and the window's down, would you expect to smell a, quote, strong odor of raw marijuana?
It depends.
Okay, depends on what.
So there's multiple ways that marijuana is packaged. If it's open, like you said, it depends if there was other marijuana in the vehicle earlier. It's a very pungent smell, marijuana does. So there's marijuana in a location, just like anything else that has a pungent smell. If it's inside a car in a closed space, you take it out. Like, say bad food, for example, your car might stink, but it's not in there anymore. So it also depends how it's packaged. We come across marijuana that's put in mason jars, the same amount of marijuana in a mason jar versus outside the mason jar is going to smell strongly. So you can still smell it through a mason jar depending on how potent it is. Sometimes you come across marijuana in bags, inside mason jars, in vacuum sealed containers wrapped with dryer sheets. And sometimes you can still smell it, but you're not going to smell it as strong. It depends how it's packaged, the location in the car, and how long it's been in the vehicle.
So are you saying that if marijuana was in the car and then it was taken out of the car and there was no marijuana in the car, you could still smell a strong odor of marijuana in the car? Is that what you're telling the jury?
So
Is that what you're telling the jury? That's my question.
you're asking,
It's a yes or no question.
can you rephrase that?
Is it your testimony? Are you telling us that if there is a amount of marijuana exposed to the elements in a car, let's say the size of a softball, and I remove that marijuana from the car, and maybe a couple of hours pass by, are you saying that you'll be able to smell a strong odor of raw marijuana? Yes or no?
Sometimes that's true. Yes.
Did you read the entire report from this incident, including all the supplements that were prepared by all the officers?
I don't think I did. It's possible I could have. I did not read anything anytime recently. I'm talking in years.
But at some point you did, correct? I mean, at some point you did, right?
I don't know if I read all the supplements.
Okay. Would it surprise you
To be fair, Kimbo, that's Springfield. So there you go. It's my people down there.
if there are zero supplements from any police officer that say anything about the smell of marijuana? Yes or no?
I would be.
Okay. So when we're done today, I'm just going to ask you if you can go back, look at reports, and if you find one where that's true, let me know because I'm going to recall you for that purpose, okay? I'm just asking you that.
I'm familiar with one. Yes.
Okay, which one?
Okay, the face sheet of the report. Matt Gilmer wrote this report because I was in the hospital. I did a supplement talking about some of the fighting. On the front page, down at the bottom, Matt wrote in that there was a traffic stop and an officer smelled the odor of marijuana coming from the vehicle on the front page of the report at the bottom.
Okay, so he prepared the report, but he got that information from your report, right?
No, Matt did the report when I was in the hospital.
Have you seen Gilmer's supplemental report?
I do believe I read Gilmer's report.
All right, I'm going to show you Plaintiff's Exhibit V. And for the record, it's 2 and a partial written pages. Read that through to yourself and tell me when you're done. The question is, look at that report and see if you see anywhere in Gilmer's report where it references an odor of marijuana.
This is not Gilmer's entire report. I can tell immediately.
But, okay, so what you have in front of you, those 2 and a quarter written pages, I want you to look at it and tell me, answer the question.
In this pages you provided, I'll look.
While he's reading that, I thought I needed to caution you all about TV. I know that this is being covered by the TV, but please remember not to get outside information. The courtroom is where you have. And the most jewelry room is from library, and you're in there because it's a larger room. I know there are law books in here, but you don't want any instant lawyers. No instant lawyers.
I don't see anything in the pages you provided
Okay.
referencing the odor of marijuana.
Okay. And are you aware of any other pages that might have some reference on from Gilmer?
Yes.
So if you find something like that, let me know, and I'm going to recall you, okay?
It's on the front page of the police report. I have it. I'm letting you know. You want me to get down?
I'm handing you a document, single page, marked Plaintiff's Exhibit X. Can you identify that, please?
This is the first page of the police report, 17055 or 5661 for this incident.
And what does it say in reference to what you're referring to?
So the report's made by Patrolman Gilmer.
What does it say?
It says police conducted a traffic stop on East 228 Lakeshore Boulevard. The male was discovered to be suspended. The male driver was discovered to be suspended. Officers also detected an odor of marijuana. Officers, the driver and front seat passenger were arrested.
Doesn't say what officers, right?
It says officers, correct?
It doesn't say what officers, right?
Right.
In your report, you say that you smelled a strong odor of raw marijuana, right?
Right.
In Officer Gilmer's 2 1/4 page report, which is Exhibit W, which you just reviewed, which he authored, and his name is on the bottom as the author, he doesn't mention that anywhere in those 2 1/4 pages, correct?
He does
Is
not
that
offer it in the 2 1/4 pages that you provided, correct?
Yes. I'm going to show you a photograph marked Plaintiff's Exhibit R. Ask you if you recognize it.
I don't.
Do you see?
I've seen it from the report. I'm familiar with it.
Okay.
I didn't photograph it or collect anything.
Okay, so in the Gilmer report that you just read, the one that he authored, Exhibit W, doesn't it say that I, Officer Gilmer, searched the vehicle, I located some marijuana in the center console, Officer Fito photographed it, and then I submitted it to evidence. Is that accurate?
You're saying Exhibit W? On this?
Yes.
V?
Is it on there?
This is V.
Oh,
And your approach.
you may.
So and I'm sorry, I stand corrected, it is Exhibit V. So in Exhibit V, Victor, which is Gilmer's 2.25 page report, you see on page 2 towards the bottom where Gilmer says, I searched the vehicle and located some marijuana in the center console. Officer Fito photographed it. I collected it and submitted it as evidence. Do you see that? Yes or no?
Yes, I do.
And so then that photograph that you see there, Exhibit R, does that appear to you to be what was photographed by Fito in the center console?
It is my belief this is the photograph of the area it was collected for the report, but I didn't collect it. It says the area the marijuana was collected was photographed. I don't know if that means the marijuana was photographed. I did not collect it. So I know this is from their vehicle. I didn't collect the marijuana. I didn't put it in evidence. I didn't test it. It's just done by other officers.
You believe that that is a photograph? You believe that Exhibit R, is a photograph of what is supposed to be marijuana, yes or no?
Objection.
Overruled. Overruled.
The only reason I'm
Do you
hesitating,
believe, yes or no?
for the report says this is where the location was recovered, I believe, was photographed.
Looking at the photograph, do you believe that's a picture showing marijuana that was collected? Looking at the.
I see green specks in this photograph.
I'm gonna ask it again.
I don't know, sir.
You don't know whether it's marijuana or not?
I don't know.
Is that your comment?
Yes, sir.
Next question.
Other than that photo, are you aware of any photographs of any marijuana that was collected?
I'm not.
Assuming, for the sake of this question, that what's depicted in plaintiff's R is marijuana, those flecks, do you know where that is today?
Yes,
Where is it?
it was destroyed.
You know when it was destroyed?
It was destroyed a couple years ago by the narcotics unit.
Okay, I'm showing you a document marked Plaintiff's Exhibit W. It's 2 pages. Can you take a look at that? Just identify it for the record. Yeah, it's W.
Okay, this is, appears to be sworn evidence destruction, which is something that we typically do. We don't keep evidence forever. And do you want me to match the report number up?
Yes.
5661. Okay, it says, this is from the narcotics unit. This is Sergeant Ariza. And it says, I hereby swear that the evidence property listed previously submitted 93 type pages of destruction inventory from the narcotics room was destroyed in the Euclid Police Department on November 11th, 2019. November 11th and November 18th, 2019. There is a listing that matches this report number. It's 17-05661. 17-0. I'm assuming it would be the previous case, 17 CRB 01464. I see marijuana was destroyed on 8/12/2017. That's the only.
And the marijuana that was destroyed has the same case number as this case, the Hubbard case, correct?
Correct.
And do you know if anybody, either Hubbard or Caraballo, were charged with a marijuana offense as a result of whatever was found or allegedly found?
I know they were not charged.
Okay. Officer Amiott, one of the most important things in police work is truth and honesty, correct?
Correct.
And that goes also in preparing reports.
Sure.
How long have you been with Euclid City PD?
I testified in August of 2014, so 8 years, going to my 9th year, 9 years.
When did you start?
August
August what?
August of 2014.
And where were you employed before that?
North Kingsville.
North Kingsville Police Department?
Correct.
How long were you employed at North Kingsville?
I was only employed a few months in North Kingsville because Euclid will not allow you to carry 2 badges, and Euclid pays significantly more. So,
Were you employed for 1 month there?
I thought it was maybe a couple months, but Euclid said I have to either leave North Kingsville or come aboard Euclid, so it's what I did.
What about before that? Where were you employed?
City Mentor,
When were you employed in the city manager?
2013 and 2014.
Why did you leave the city manager?
Objection.
Overruled.
Why did
Judge
you
be
leave?
reproached.
You may.
Mentor is a nearby suburb over here on the east side. So we'll talk about that in a moment.
I know, I can't tell Tom, okay. Right. Blame me, remember that. Blame me. You may proceed now. And we will probably go over a bit today. If it gets too bad for anyone, let me know. All right? You may proceed.
Officer Amiott, I think the last question that I asked you had to do with your employment at Mentor, correct?
Correct.
When did you work for the Mentor Police Department?
2013 to 2014.
What was your last day at one?
April 2014.
If I tell you that you submitted a resignation on April 3rd, 2014, would that refresh your recollection?
Sure.
And why did you submit that letter of resignation?
Because I was resigning.
Is it true that on April 3rd, 2014, Chief Knight brought you into the office and told you that as a result of an internal investigation that was completed, alleging that amongst other things, you falsified information on a police report, he was going to terminate you that day? Is that a true statement?
Yes.
And then, is it true that when he told you that, without prompting, you asked the chief if you could have the opportunity to resign? Is that true?
Sure.
And then is it true that on that same day, April 3rd, 2014, the chief's office prepared a one-sentence resignation letter for you, and you signed it? Isn't that true?
That's true.
And isn't it true that then that was your last day of employment there, correct?
That's true.
Thank you. No further questions.
Read the back.
Thank you. Officer, were you a new officer during that incident
Yes.
in Mentor?
Yes.
And was there an investigation done?
It was.
Did that investigation produce a conclusion?
Yes.
Do you remember what the conclusion of that investigation was?
The conclusion of the investigation, they mentioned that it was obvious I was being truthful during the investigation. There was probable cause to stop the vehicle in question. And they said that I should have had better, as a new officer, better knowledge of law, if I remember correctly. This is going back 10 years. So.
Refresh your recollection to look at the investigation.
Sure.
Make sure you may approach. It's been
Can
marked
I
as.
see what you're showing me, please?
Sorry.
Yeah, no, it was 20 something.
I'm sure it's been marked as offense 17.
Has to be 18,
Wait, so we marked that?
17 with physical therapy.
Okay, I'm sure it's been marked now as offense 18. Is that a copy of the internal investigation done relative to the issue that
It is.
Antonio just brought up?
Yes.
And if you go to the last page. You see a highlighted section?
Yes.
What is the conclusion of that investigation based on the highlighted sections?
The highlighted section says Patrolman Amiott was honest during an interview with me and Lieutenant Allen. Patrolman Amiott told dispatch during the stop he ran the driver a few days ago, and he showed to be suspended. Patrolman Amiott took his time to review his in-car video before completing his report once he realized the car was not required to have a front plate. When he followed the car from Federated Auto to Hollycroft Lane to make the stop, he was trying to run the plate. He had thought he'd already had probable cause for the stop based on the lack of the front plate. The weave made on Menor Avenue, although slight, could be interpreted as sufficient reason to stop the car. His actions during and after the traffic stop were done due to lack of knowledge rather than deceptive behavior. The only policy violation I found as a result of the investigation was knowledge of laws and regulations.
Thank you. Going back to the relevant issue here, is the name Yolomar inherently male or female to you?
No.
In today's day and age, or any day and age, is it easy based on just a glance appearance of someone to determine their gender?
Is it?
Easy in every situation. So let's say someone has long dreads or a woman has short hair, it would be immediately apparent to you every driver what their gender is, correct?
I wouldn't say every single time.
But that happens on occasion.
Yeah, occasionally, sure.
Officer, you testified that you ran the leads on the car, correct?
Correct.
And it came back to the driver having a suspended license.
Correct.
Was that true? That the owner has a suspended license?
Yes,
And in fact, the owner was in the car
the owner's in the car.
and
Correct.
she had a suspended license?
Correct.
How about the driver?
The
He had a
driver,
suspended
yes,
license?
he has a suspended license.
When he gave you his ID card, can you tell by the look of the ID card whether or not a person has license?
Yes.
How?
It says non-driver Ohio ID.
Okay. And can someone have a driver's license and a non-driver ID?
No.
Why?
I mean, you could, but it's illegal to be in possession of more than one. I think it's an M1, and the DMV usually takes your.
So you know immediately upon seeing that ID that this person doesn't have a license.
Correct.
That's a reasonable assumption to make.
Correct.
Why don't you call in a warrant check while you stand next to a vehicle?
Well, we would never do that for obvious tactical reasons. If the person in the car is wanted, they're going to be able to hear your radio traffic, and that radio traffic, say it comes back that the person's wanted, then they know that you know that they're wanted. You don't want them necessarily hearing the radio traffic. Right? You don't want the suspect or the violator necessarily to know the information that you have at the time. I've actually, I don't know almost any situation where you just stand there and run it.
And this wasn't a situation where he didn't realize his license was suspended or his insurance had lapsed, right? He was aware of it, he didn't have a driver's license.
Objection.
What were you doing? I can rephrase.
They probably-
Were you here when he testified that he didn't have a driver's license and he knew he didn't have a driver's license?
Correct.
Would you agree if I said this whole interaction that we've seen on this video many times took about 2.5 minutes?
That sounds correct.
And that each movement we've had hours, days, years to reflect on, you had in total 2.5 minutes to make all of those decisions, correct?
Correct.
When you're answering the prosecution's questions, they were phrased as, do you see on the video that this?
Correct.
Testifying to what you see.
Correct.
The same thing the jury could see.
Correct.
Are your determinations of force based only on what can be seen or all of your perception?
All of your perceptions.
And there are times where your perception is more inclusive of information than simply what can be seen on video?
Correct.
The state phrased a lot of their questions to you as yes or no.
Correct.
Is it difficult to answer forced questions with yes or no answers?
Yes.
Why?
Well, there's more going on, and the way the video was paused and stopped, I just wanted to make sure I was being clear about what exactly was happening in the video when he was talking about it. And there's also things in video you can't see: resistive tension. You can't see things that I can see that you can on the video. That there's things in the video that you can't see that I can see. There's also things on the video that you can see that I can't see. Like when he reaches down with his hand and stuff like that, I can't see exactly what he's reaching at if I'm not looking there.
And in assessing force, is there always is it a reasonableness standard?
Objectively reasonable standard, yeah.
Okay, so you're looking at all of the considerations, the circumstances known at the time, and weighing those, correct?
Correct.
She's leading. Next question.
Can you answer the question?
He did. Next
I'm
question.
sorry, what's the answer? Yes.
Correct, yes.
Does a weighing test lend itself to yes or no questions?
Can you rephrase?
A test where you have to weigh a lot of considerations. Does that lend itself to an immediate yes or no determination? Maybe it's a confusing question.
Yeah.
Do you have to consider more things than might have been posed to you in the question in order to determine whether force was reasonable?
Correct, yes, yes.
So one still frame doesn't indicate yes or no to any force.
Correct.
So you look at the totality of all of the things that occur up until that moment.
Yes.
You did not handle the arrest of Carabello, did you?
I did not.
Okay. And you didn't handle photography for search of the car, did you?
I did not.
And you didn't handle the citations of either Hubbard or Carabello, did you?
I did not.
And you didn't make any determinations about what inventory would be destroyed and when, do you?
No, that would be the narcotics division.
Okay. And you stated that you smelled marijuana.
Correct.
And was there marijuana in the car?
Correct. Yes.
Oh, I'm sorry, Mayor.
You may.
Did you attend the police training offered by the city of Euclid
The most recent training?
in 2017?
Oh, in service training, yes. I would have been there.
Okay, and this in-service training would have been in January of 2017?
That sounds correct.
And was it mandatory for all officers?
Yes.
And did that training help establish your understanding of what is and is not permissible?
Yes.
Did Law Director Kelly Sweeney handle that training?
Yes, I believe she was assisted by the city prosecutor as well.
Okay, I'm going to show you what's been marked as Defense Exhibit 6.
This is the 2017 winter in service training.
No question.
Are those the slides that were shown to you as a part of that training?
Yes.
Were there slides relative to the propriety of a stop when you were on a lead violation, or leads?
There were. There's several things about traffic stops here. I'm going to read them all. Or...
Read the ones that were relevant to your training and your understanding in 2017.
An officer has reasonable suspicion to stop a vehicle after he ran the license plate and discovered the car was registered to a person with a suspended license, Steve Jones, 2004.
And so in a training, would that have been projected?
Yeah, so
outside?
we have a training room computer downstairs in the training room. There's a large it's projector on the wall.
And so this was the standard presented to the Department by Law Director, is that correct?
Correct.
Okay, are there other slides relevant to traffic stops or arrests?
There's several slides here. There's one about ordering occupants out of the vehicle on a traffic stop.
And what was the Euclid Police Department instructed by the Law Director related to?
Provided that the officer lawfully stopped the vehicle, all occupants may be ordered out of the vehicle in the interest of officer safety. If any occupants may be considered armed and dangerous, the occupants may be frisked. The officer also may search the passenger compartment to look for weapons. And cites Pennsylvania v. Mims, 1977, U.S. Code 106. And then there's authority to remove occupants from the vehicle does not automatically give rise to an authority to frisk. It must be reasonable, applicable facts and circumstances, giving rise to reasonable fear of the officer's safety.
So it's fair to say you were literally trained on the exact nature of the stop that happened on August 12, 2017.
Yes.
And as a result of that training, is it your understanding that that stop was lawful and permissible?
Yes.
Is that still your understanding to this day?
Yes.
In the incident in Mentor, what was the race of the driver?
There's a white male.
Anything further with this witness?
Just a couple of questions,
You
basically.
may proceed.
Officer Amiott, that document that the defense, that Corral showed you, that you read, was written by who?
The PowerPoint, yeah, it's, yeah,
Let me see that thing. No, the one first document you showed me.
Is it up there?
I believe it is.
Check, see. No, that's not it. Check the documents over there. Now, check the documents there.
There.
This exhibit 18, you recall this was shown to you by Ms. Corral?
This is the, yes.
Is that the one she
Yes,
showed
yes,
you
yes.
just a few minutes ago?
Yes, you did.
That's the one you read from the last paragraph that indicates you were honest during the investigation, correct?
Yes.
What's the date of that document?
3/17/2014.
3/17/2014, and it's authored by who?
This is from Sergeant Richard Slovincke.
Okay, and that was part of the internal investigation that Mentor did?
Yes.
Let me see what you have.
She's one.
Let me see what you have. You may proceed. Overruled.
So that document you looked at, reference to the internal investigation is dated what?
3/17/2014.
Then I asked you to look at states why. Tell me what date that document is dated and who authored that?
This is 3/5/2014 from Sergeant Michael Klosky.
Is that in connection with the same internal investigation?
It is.
Can you turn to the last page and read the first sentence in the last paragraph?
In summation, it appears Patrolman Amiott fabricated a weaving violation once it was brought to his attention that there was only one dealer plate and not two plates on the vehicle.
And that's just another part of the internal investigation, correct?
This was what started the internal investigation. This was an allegation and then the internal investigation.
And then we already talked about, you were in the chief's office on 4/3/2014, correct?
Question asked and answered.
I'm going to follow up.
Overruled.
Yes, that's correct.
And then, isn't it true that before he told you that he intended to terminate you on that day, he told you exactly why, right? Did he tell you the four policy?
I was given a document. I don't remember if we went over them, but I'm familiar. Yeah.
Tell me if do you remember what they were, the four violations he said he found as the basis of the firing? Do you remember?
Objection, said he didn't remember.
If he doesn't remember, you can refresh his memory.
Would it refresh your recollection if I told you that Chief Knight found that you violated
Let him see it. So
So if you want to take a copy of this document, I never possessed it.
overruled. You may continue.
Well,
Deputy would need to.
I'm going to show you this document that I'm going to mark as plaintiff's exhibit Z. Do you see that?
I do.
Date that?
Yes.
Is that an indication where the chief indicated that he's gonna let you go on 4/3/2014, and then you said you would resign? Is that document?
That's correct.
And up in the second or third paragraph, does it indicate the 4 code violations that he found that supported that?
It does.
What's the first one?
Truthfulness,
And what code is that?
2.1.26.
What's the second one?
2.149 reporting,
What's the third one?
2.164 reports and booking,
And then what's the fourth one?
2.169 arrest and search and seizure.
And he told you that that was the basis that he was gonna let you go on that day?
Yes.
And then you offered to resign and he let you quit?
Correct.
Okay.
Anything further of this witness? Counsel, anything further of this witness?
I'm sorry, Judge, I was thinking for a moment.
Okay, any questions or not?
May I have one moment? I'm looking at the document.
Okay, go ahead, counsel. Look at it. Are there questions from the jury? Okay, you can pass them down to the end. You can continue, counsel, if you have questions, or not.
I have none, Judge.
You all want to approach and review these, you may. Stand up next to each other, please. Yeah. Any comments?
No, Judge.
Counsel, any comment? You can't talk out.
Okay.
You testified concerning injuries to your hand, correct?
Correct.
How could you punch with a broken hand or dislocated hand?
You can punch with a broken hand. You can still fight. Suspects can still fight. You can still make a fist. I had a problem with the hand though. I couldn't straighten my fingers on the left hand. At least these bottom two. This one was broken and curled in, and these were sprained.
And you were still capable of punching?
Yes.
Okay. In 2016, Mr. Hubbard did not have locks. Today he does. There was reference made to that. Did he look like a female in 2017?
I don't know that I looked at him for sure in the car. I drove through that intersection today.
Wait. Answer the question and not.
I'm sorry. The question was, did he look like a girl? Was it?
Did he look like a female in 2017?
He did not.
Okay. Did you stop him for running a red light or failing to stop at the stop bar?
The red light ordinance.
Guys, that part right there. You guys heard a bunch of that. Notice they said, did you check to make sure there's a woman driving the car? Let's go back to that question because that's a critical question. Did you make sure it was a female?
I don't know that I looked at him for sure in the car. I drove through that intersection today.
Answer the question and not.
I'm sorry. The question was, did he look like a girl? Was it?
Did he look like a female in 2017?
He did not.
Okay. Did you stop him for running a red light or failing to stop at the stop bar?
Now, if he had not stopped past the stop bar and all they had was a suspended license issue, he just admitted they would not have probable cause because he admitted he didn't check to make sure it was male or female. So without Richard Hubbard stopping like a moron and stopping at the stop line, they probably wouldn't have been able to stop him. Critical stuff.
The red light ordinance, it's restricted to red light ordinance.
Hold on, answer my question. Did you stop him for running the red light, or did you stop him for not stopping at the stop bar?
The stop bar.
You stated that, how many people were in the car?
The Hyundai, there were 2 people in the car.
Were you in extreme, maybe I'm repeating here, but were you in extreme pain when you broke your hand or injured your finger?
My hand, yes, it was.
Did you feel limited in your abilities because of your hand?
Yes.
Is that correct?
Yes.
Okay. Questions based on these?
Just one. What is the difference between a stop bar violation and a red light violation?
There's not one.
It's the same charge?
It's the same charge, and there's several things in that ordinance.
Okay, thank you.
Council, questions based on these?
No questions.
Hopefully this was responsive to your questions. If not, you need to write additional questions, you may do so. Thank you all. You may step down. We're going to allow you to go home again. We're not going to keep you any longer. Remember the admonition, critically important that you remember the admonition. These cameras are here for a reason. And you need to make sure that what you take in and what you use here comes from here and here. Be safe. Have a good evening. All right.
All right, chat. So it's the end of day 3 right there. We're going into day 4. Why was the judge asking questions? The judge can ask questions. The judge is allowed to ask questions. April. A judge or a magistrate who is proceeding over a hearing, they can ask questions of a witness too. But remember, he was on those written slips of paper. Those were questions from the jury. Those were questions from the jury. So he was asking their questions for you, for them. They are also allowed to ask their own questions. There are, let me see here. How many witnesses are left? We have... there are 5 witnesses left. 3 of them are police officers. And then there are 2 experts, including another guy who trained Michael Amiott, and then their force expert. So, a couple of questions we are going to try to answer here. Tim says, what does the marijuana or lack thereof have to do with the charges of assault? Normally, the prosecutor's using defense attorney arguments right now because he's saying at this point, if there's marijuana and I take it out of the car, can you still smell the presence of it later? And the answer is yes. Now, if you try to ask that in any other marijuana case that the prosecutor's going to have, he's going to say that's bullshit. The smell lingers. Smells can linger. You cook fish. Does that mean if you could smell fish right now, does that mean it's cooking right now? No. You cook something in your house and it stinks up the joint. Does that mean it's still there? No. Sometimes smells linger. They'd point out like you can remove something from the car just now. So he's using some defense attorney arguments there, which is very funny because I haven't made those arguments before. Isn't weed legal by now? Dodo Shwedo, this occurred back in 2017, and it's this trial occurred in the summer of 2022. So no, weed was not legal in Ohio in 2017. Ashley Casey said, what did he get fired for? From what I've been told, there were some issues with him being untruthful during internal investigations regarding some things from the Mentor Police Department. That's the allegation, what I've heard from people who I trust with the knowledge and run around in this area, that he was fired because of those issues. And Mentor, Ohio is one of the suburbs over here that is right next to Euclid. So I think he was given an opportunity to, like, you're going to leave or we're firing you. Manny B says, so he lies on reports. Well, I'll let you make that conclusion yourself. Like I told you guys, there's a little bit of story to this that we learn. Alex Say Maniac is saying, why should they need to verify if the driver is the one with the suspended license to pull over the car? Isn't that reasonable? It's not that. So here, we'll use an example. So 2.0 or 2. So my car is driving down the road and my license is suspended. Okay. 2.0 is driving the car though. And a police officer pulls up behind it, runs the plate, and it says, oh, the driver of this car has a suspended license. So the driver starts following, or the police car starts following 2.0. He then realizes that there's somebody up in the front driving. Okay, who is it? And he pulls up next to us and sees, oh, it's a woman. And he pulls up, who owns the car? Sean Martin. Sean Martin does not look like 2.0. He would then no longer have cause to stop that car based on the suspended license. Okay? Because at that point, it's clear that Sean is not driving the car. If there was, if it turns out I'm white and the driver's black, well, there's, no longer reason to believe it's the same person. Reverse the races, reverse genders, things like that. There's multiple ways you can do that where they lose the probable cause for the stop, the reasonable articulable suspicion for the stop, like immediately. If they can realize, oh, that's not the person we're looking for. It's not the droids we're looking for. So that's part of the issue. And it sounds like at that point, he realized it was a woman. Like he's claiming, I didn't know who it was for, but the driver was bad. I didn't hear her gender, so we stopped him. But either way, remember, stopping past the stop line is like running a red light. It's an offense. It's a chicken shit offense, but it's one he can arrest for nonetheless. Dagamore is saying, did his training state if running the plates with a registered owner with suspension, they have to do the stop? No more info from that side, right? Or did I hear that wrong? Yeah, no. If that's enough, if they think there's enough there that I can articulate, it's likely that person's driving the car.
The course of the case.
That's kind of where we are. Dry Book says Sean could have a wound. Well, thank you. Nicholas says that chicken shit offense gets a lot of pedestrians hurt. Well, in this situation, it didn't. Maddie says, does the MIMS allow for searching the vehicle or just removing the passengers? Generally, just removing the passengers and the people in the car. But then there's Michigan v. Long, where you're allowed to, like, frisk a vehicle for weapons. Yes, it's an actual fucking Supreme Court case where they frisked a vehicle for weapons after they got him out of the car. So, yeah. Excited Utterance says, what's up? Not much. How are you doing? Guys see hella hearsay for days. Sundays at 4, among other things she does. Ashley says, how do you frisk a car? They search in your immediate area where you're sitting if there are weapons there. Like I said, there is some bullshit Fourth Amendment law out there that's survived. The Rehnquist court was horrible for civil rights. Yeah, you do it very gently, yes. So, anyway, we're going to keep going here, guys. This is the next day. Yeah. So, as a man, can I request a female cop to frisk me? No. So, and yes, Maddie, as I stated, yes. Anything in your wingspan, basically it's called the wingspan issue. It's a case from Schimel v. California. there's like the wingspan rule. Like everywhere right around that person, you could search. So, but yes, there's, hold on here. We'll bring it up. Let me see. Is there? So, anyway, here is the case of Michigan v. Long. I know you guys, like I said, Wikipedia does a great job of bullet pointing this shit. Anyway, so here's what happened in Long. He was driving down the road, went into a ditch, got a DUI. They suspected. They saw a hunting knife on the floor of the car, and they patted down Long. They gave him a Terry frisk. They turned up no weapons. So remember, Long is outside of the police, out of his car at this point. All right. They then conducted a protective search of the car, searching for weapons. Inside, they found a bag of marijuana, which then allowed them to search the entire car. And then they found 75 pounds of drugs. And they said the protective search of the passenger compartment was reasonable under the principles articulated in Terry. And you could thank fucking Chief Justice Berger for that one. It was a fucking awful, awful, awful fucking decision. Awful decision. Brittany says that's basically around the car except behind the driver. For the most part, yeah. But yes, so guys, I'm not joking. The cops could say we had to frisk the car. And it's not completely retarded. So, Tim's just going to amend this case. It only applies to black people. No. Anyway, guys, like, I'm not joking. The Fourth Amendment, like, you hear me say that the Fourth Amendment has taken a beating over time. This is how fucked up it is. This is how bad it is for the Fourth Amendment that these things exist. Like, when I talk about, like, warrant exceptions and bastardization of the Fourth Amendment, this is a great example of it. This case right here, think about it. We have the guy in the car. He can't get in the car. Well, there might be weapons in the car. Then don't let him in the car. Like, yeah, this is. So Nick's warrant was unconstitutional. No, Tim, Nick's warrant was not unconstitutional. I believe it's fully supported by probable cause. Yes. Nick wins again! All right. So we're going to move on to the next day. There's some actual interesting stuff here we're going to get to. There's some arguments that are made. Bricks the size of tires. Yeah. Well, yeah. Yes. There's nothing like that says intelligent like getting drunk with 75 pounds of drugs in your fucking trunk. That's really retarded. But anyways, here we go. Here we go. We're almost getting there, chat. So we're gonna plow through this, and we'll plow through the rest of it. Ready? Here we go.
4 police officers since State v. White. Randy Connor holds that the plaintiff has the burden to show that Officer Amiott's conduct was unreasonable in light of then existing circumstances from the perspective of a reasonable officer on scene.
Now they talk about Graham v. Connor, and we need to get to this. Graham v. Connor is an old school case. If you guys listen to in old school, it's a 1989 case. If you guys listen to the civil rights lawyer, John Bryan, he talks about Graham v. Connor all the time. Graham v. Connor is that the objective reasonableness standard should apply to a civilian's claim that law enforcement officials use excessive force in the course of making an arrest stop or other seizure of their person. So Graham v. Connor is kind of like the, you use the objective reasonableness standard. So you hear about Graham v. Connor, this is where it goes from, okay? So that is where we get to here, okay? And it's, like I said, we're going to use the cheap head note here. An objectively reasonable standard should apply to a free citizen's claim law enforcement officials use excessive force in the course of making arrests, investigatory stop, or other seizure of their person. So Graham v. Connor is a defining standard. Yes, there are multiple Graham factors. Not Graham crackers, there are Graham factors. And there are multiple factors here. There are 4 factors that affect the force. Basically, it's kind of like you have to look at them like this. It's the severity of the crime, whether or not the suspect was an immediate threat, and whether that suspect's trying to evade arrest. Those are 3 of the 4, and then the 4th one you could argue the objectiveness of the issue. So those are roughly the 4 factors for Graham. You can break them down to intensity, duration, immediacy, and objectiveness. So that's those are the bullet points for it. And it's still valid law today. How many grams, Sean? Answer the question. Graham factors go great with chocolate and marshmallows. I hate my life some days. Some days I hate my life. Oh, God. We can make s'mores now. Oh. Self-defense attorney. Fat man. Notice I'm the fat guy and I'm not going, s'mores. Oh. S'mores are not sandwiches. Well, that's also fair too. So. Malomar? Oh, who the fuck eats Malomars? Jeez. It's like telling me you like moon pies. Ugh. So here we go. Anyways, let's get back to this. But you can see you're talking about just going over some issues here.
The state, for some reason, believes that it should be an affirmative defense and that an affirmative defense should be thrust upon us. We have not requested an affirmative defense. We would not request an affirmative defense. We would object to an affirmative defense if both parties have briefed that extensively for the court prior to trial. When we began seating a jury, the court instructed the entire jury veneer that the state has the entire burden of proving the case. Subsequently, I asked, Judge, should we take that as your ruling on the burden of proof question? And you indicated that it was. Now it sounds like a burden of proof question is back at play, and I would note for the record that would have affected, we would have one-year the jury as to the switching of burdens if that had been the court's ruling, but it was not. We now have a jury which was instructed and which was, the state has the entire burden, and which was not one-year on the concept of burden shifting. An affirmative defense places the burden on the defense at the standard of preponderance of evidence, which we believe is unconstitutional, inappropriate, not supported by legal holdings, and the only holding that the state has cited in support of its position is a holding in which the state's counsel himself, his firm, was defense counsel in that case, and they asked for an affirmative defense instruction. We are not asking for an affirmative defense instruction. We would object to one, and we have again been put in a situation where the rulings being made mid-trial affect the way trial strategy would have been handled from the beginning. So here we are on our fourth day of trial. We're still not on notice as to what case number we're on. The language of the complaints aren't clear, and we're still not sure who has the burden. And so all of those are flaws which negatively affect the defense, impact the way trial strategy would have been handled, and I think create errors in the case. I would ask this court to issue a ruling that the entire burden is on the state, and that as soon as possible we get clarification on what charges this court proceeds to have gone forward for over the last 4 days.
Thank you, counsel.
Your Honor, I agree 100% that the state has the burden of proof. The state has the burden of proof to prove all the elements of the offenses charged beyond a reasonable doubt. That's law, legal, trial law 101. We all know that. I know that that's what the judge was instructing the jury on. If an affirmative defense is raised, and as the court instructs the jury, ladies and gentlemen, the state has the burden of proof because they brought the charges. They have to prove everything that they accused them of beyond a reasonable doubt pursuant to the elements of the statute. The defendant does not have to testify. He does not have to present a defense. But guess what happens as soon as you present a defense? If it's an affirmative defense, you have the burden of proof. 290105, which I stated in my brief, and I'm going to rest. I'm not going to recite my whole brief here. I'm going to ask the court to look at it. I know the court will. It makes it very clear what an affirmative defense is, who has the burden of proof for an affirmative defense, and the only exception that's been carved out of that as of 2021, I think, is the legislature said, from now on, if your defense is self-defense, the state has to prove that it wasn't self-defense. It's not a self-defense case. This is a police officer justification case under Graham versus Connor. To correct one point of the defense counsel,
And that is an issue here. You're either picking self-defense or you're picking I'm being a cop. So which one is it? And I think that's actually not an invalid distinction. You know, which one are you taking? Which shield are you going to carry? Are you carrying Graham v. Connor? Or are you going to grab the other shield, self-defense? So I don't blame her, though, for trying to make this argument of burden shifting here. I do think it's important. So
State versus Bolton case, which was a non-deadly force case, which I gave this court the jury instructions on, is an Erie County Common Police Court case. Again, non-deadly force case. There's a difference between a deadly force case and a non-deadly force case. State versus White, your House Supreme Court, makes it super clear what the difference is. That's why I cited it so extensively in my brief, as opposed to cherry picking different parts out of it. But my point is, she indicated I'm counsel on this case. I'm not. I pulled this out of the Common Police Court in Erie County. Again, it's a non-deadly force police case. Justification is the defense. The burden of proof is on the proponent when they say, my defense is justification. So there's no confusion here for the jury. That's the way they should be instructed. The final point, Your Honor, is as far as these complaints go, counsel submitted a brief motion to dismiss 19 CRP 890, and in that motion to dismiss, she cites a case for the proposition of what's necessary in order to comprise a sufficient complaint. In that case is Cincinnati versus Gardner. Here's what Cincinnati versus Gardner said. And again, this is super fundamental 101 stuff, and it says the following. It says, a complaint is generally deemed sufficient if it charges an offense in the words of a statute or ordinance upon which it is based. Of course, that's why in the legal world, every time we see a complaint, we see that it tracks the statute, just like in this case. So when the complaint in this case for an assault says, on such and such a date, defendant did knowingly cause or attempt to cause physical harm to this person, Mr. Hubbard, by engaging in blah, blah, blah. It's in the complaint. And that's enough because all you need is a statute number. It's got to be made under oath, and it has to have those elements in it. That's all the law requires. All of that stuff is in all three of those complaints in 890. All of those elements are in all of the three complaints in 921. The only difference is, as counsel pointed out, that 921 complaints add some more facts. But at this point, Your Honor, I know I asked the court to consolidate the cases. I think the court said the cases are consolidated. For purposes of jury instructions, I would like the court to include the exact language of the complaints on the three complaints in the case number 890. That's what I'm asking for. The only other thing I would ask for, Your Honor, is a ruling on the motion that I made a couple of days ago to amend those three complaints pursuant to Criminal Rule 7D, which basically says a court can amend a complaint at any time before, during, or after trial for any manner in form or in substance, regardless of its form or substance, so long as you do not change the name of the crime and the section number of the crime. I'm not asking you to do that. As I explained last time, the only thing I'm asking for is on the face sheet of those 3 complaints that the court has in its possession in 890, at the top, it says summons. My motion is that the court amend it to say complaint, because indeed it is a complaint. As we all know, a summons is something that says, hey, come here. It's a summons to bring somebody someplace. And we all know that when a complaint is issued, the next step is a summons. And as I pointed out, case 890, we have the 3 complaints. They were signed, sworn to by the deputy clerk, Kiera McLean, on 8/6/2019. They were signed by Richard Hubbard. And then on that very same day, as the docket reflects and as the paperwork in the file reflects, certified mail was sent to the defendant to summon him to appear here. And he appeared here through counsel. He entered a plea of not guilty. Those aren't issues. So again, I'm only asking that the word summons be changed to reflect what it truly is. It's a complaint. Anybody reading it would say, oh yeah, this is a complaint. It alleges assault. It alleges violation of civil rights. It's signed by the complaining witness. It's witnessed by a deputy clerk, and it's certified.
Thank you. Counsel?
Yes, as a preliminary matter, the state repeatedly has claimed that this is case law 101. This is known to everyone. This is basic. And I want to be clear on the record that what he's trying to do is disparage defense counsel and defense's position by suggesting that the claims we put forth by the court would be so basic as to be laughable. I find that tone both disrespectful and inappropriate, and I would like to note it for the record.
Okay, hold on, counsel. You've noted it for the record. As I stated in chambers, I try to be cordial and get along. I'm going to ask you, you both are professionals. Not your first rodeo. And the barks back and forth are inappropriate. I'm not going to have it. Bottom line. You're at war in here. It's a war. But your conduct, demeanor.
He's not changing the charge mid-thing. He's changing it to reflect that it's a complaint, not a summons. So he's still asserting assault and the deprivation of rights. Those charges haven't changed.
Not going to happen. Bottom line. You may continue.
I agree, Judge. Thank you. Continuing, the case that the state just cited, I believe it's Gardner versus Cincinnati, is a 1991 municipal court case, which isn't controlling on this matter at all. Criminal Rule 3 specifically states that a complaint must set out the facts which constitute the violation of the charge. The first non-complaining summons, which we want to be a complaint, does not set out those facts. As far as the issue of affirmative defenses, he's correct. 290105 does establish affirmative defenses in Ohio. They're expressly enumerated. They include a wide range of affirmative defenses, none of which is police defense. Police defenses are not an enumerated affirmative defense in Ohio, and the only exclusion, a justification defense from the enumerated defenses, does not apply because in any police case, as this court instructed when Mr. Amiott took the stand, the defense is not required to testify. If it were an affirmative defense case, he would have the burden to testify, and in fact, he does not in this case or any police case. So while 290105 is the controlling law for affirmative defenses, an affirmative defense is not asked for here, and the affirmative defense statute does not apply to police officers. Graham versus Connor.
Now, do you guys get what she's saying? Her argument is, you said he didn't have to testify, and everybody agreed he didn't have to testify. And her argument is, because of that, the state has stipulated then tacitly, or how did he say it? Tactically. Tacitly. They tacitly have agreed, therefore it's not an affirmative defense. Therefore, the burden is entirely on the state. Completely. And I think that's a fair argument.
Creates a predicate consideration. That language is exactly in the United States Supreme Court holdings, and it's in the Ohio Supreme Court holdings, and it's in the Sixth Circuit State v. White case, which was affirmed by the Ohio Supreme Court. Predicate meaning the first consideration is whether the officer's conduct was unreasonable, given the circumstances and perspective set forth earlier. Then it goes to the consideration of the elements of the crime charged. That language is very clear. So the difference is, we believe the Graham versus Connor instruction goes before the elements of the charge. The state is trying to say, well, if we show that there was an assault, then they have the burden of showing it was reasonable. There's frankly no case law to support that but for, and I apologize if I said he represented the defendant who asked for that instruction. His firm represented the defendant who asked for that instruction. So I will make that clarification. Thank you.
All right. In reviewing case 9890 and looking at the document that says summons, the court, in reviewing that, notes that it contains each one of these 3 charges, contain all of the information necessary to make it a complaint. The fact that it's denoted summons, I don't think at this time, based upon, even if you look at all of the actions of everyone, in spite of what my previous rulings may have been, it is a complaint, although it says summons. And the plaintiffs or the state's request to denote it as a complaint, and the court will do that at this time, so ordered. With respect to the court's instructions or discussions with the jury at the beginning of the case, and during the course of the case, and prior to the defendant testifying even, not being required to testify, not having to prove anything, that's a true statement. And it's a statement that I make whenever I'm instructing a jury and letting them know their purpose in being here and the roles of each party in the case. The plaintiff in the civil suit, the state or the city in a criminal case. They have the burden of proof, they retain the burden of proof. Now, the fact that you may have said, does that mean he has the burden of proof? And I said yes, then the answer is still yes. However, with respect to any matters that the court determines the defendant must go forward on, even with the burden of proof on the state, then they will have to go forward with it if they want to prove it or not, if they're required to go forward. The arguments or the discussions during voir dire, that's something I can control, but with respect to how it was addressed to the jury by the parties, that's not my problem or concern at this time. My concern is ensuring that the jury understand who has the primary burden in this case, and also that the evidence presented is appropriate, and that they get the appropriate instructions of law. And with respect to that, several of you, both of you are going to provide me additional information, and we will discuss the jury instructions, hopefully at the close of business today, so that I can get them put together, hopefully for tomorrow. If not, then we'll be here Saturday to do it. Yes, ma'am.
I just wanted to let you know, I emailed the instructions from 2021 Safety Baker to Mitch, and I assume that's the way to work.
That's fine. Okay. He'll print them and get them to me.
Thank you.
Any other information you all wish for me to take a look at, I will. But we're ready to proceed, I think. Anything else? Bring them on. They have a seat when they come in.
All rise.
Good morning.
You may be seated. Go ahead. Good morning.
Good morning.
Welcome back. We're ready to continue our case this morning. Defense is presenting their evidence.
Excuse me one moment, Judge Restraint.
You may proceed.
Thank you. The defense will call Jeff Cutright. I'm sorry, Captain Jeff Cutright.
Okay.
Captain, please standing, raise your right hand. Captain, in this matter, do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Be seated.
If you would, please state your name, your rank, and spell your last name.
Jeff Cutright, Cutwright, Captain of the Patrol Division with the Euclid Police Department.
How long have you been with the department?
Approximately 26 years.
And you're a captain.
That's correct.
What's your assignment?
Patrol.
You may inquire.
Good morning, Captain.
Good morning.
Can you tell us what your job as captain entails?
I run the Patrol Division, which is the largest division in the police department. I also run the property and evidence room. I also handle media affairs when the media guy is not available, and just about every other job in the police department. I handle calls, I make arrests, I walk a footbeat, try to every day.
And can you tell us about do you have, in the line of your work, do you have the opportunity to participate in the review of use of force claims?
Yes, I also run the use of force committee for the city. Either every month or bi-monthly, I review every use of force report, every police report that involves any use of force, and any use of force video that is taken of the incident. I then
Now, chat, use of force is a wide range of things. If they deploy a firearm, that's a use of force. They have to report that. If they deploy a taser, not using one, but they produce their taser, that's a use of force. Brandishing a firearm, brandishing weapons is a use of force. It's part of that spectrum because sometimes, like, if I point a gun at you, you might stop what you're doing. So everything can be a use of force. I know you guys are calling him Paul Bart. He's actually not at all that. So just saying.
and schedule a use of force meeting. Attending that meeting is prosecutors, council people, sometimes the mayor, the chief of police, usually a self-defense instructor, and any other personnel that would have specific interest in use of force incidents involving Euclid police.
Okay, and so it's fair to say there's a significant amount of community oversight in that process.
That's correct.
It's not just you alone in a room.
No, the reports, all the reports are reviewed by everybody on the committee. We don't have a current council person sitting, but prior to that, council person Brian Moore represents the citizens. He reviews reports. The prosecutors, the law director, and even the mayor sometimes will sit in on our meetings and review each report. We discuss the issues, how we could have done things better, whether the use of force was objectively reasonable and necessary, and that the officer properly documented the incident in a police report or documented via body camera, dash cam, or any other instrument like photographs that we use in the process of investigating crimes and arresting people.
Why is this process so thorough?
Anytime you use force to make an arrest, it's a seizure of a person. Fourth Amendment applies. The people have rights. We want to make sure our officers are using the objectively reasonable and necessary amount of force to accomplish the arrest. If we have officers that are not performing satisfactorily, I'll recommend that we send them for training, that we work with them. A lot of times, use of force, the biggest problem I have is...
Next question.
What are some of the challenges of use of force reviews?
Objection. Has nothing to do with this case.
It's his duties. He's describing his duties and responsibilities. Overruled.
Okay, the biggest thing is documentation. That's my biggest, when I look at the video.
Objection.
Captain, go ahead and describe your basic duties and responsibilities.
I review the reports. I look at all media, including video.
Okay, next question.
Can we go back to your original answer in the prior question? You overruled that question, Judge.
I overruled the first one, then he objected again,
I just
and then I asked him to tell me what his duties were.
The question is what are the challenges of use of force review?
Go ahead and answer it. What are the challenges?
Challenges, getting officers to properly document force, why they use that force.
Objection.
Overruled. Go ahead and Is that the conclusion of your answer?
Well, I look at the reports, and if they're not properly documented, I have to dig more and find out more.
Okay. Next question.
And how long have you been in the role of reviewing use of force reports?
Since I've been captain, approximately 3 years.
Did you review the use of force report in the case of Officer Amiott?
Not with the use of force committee, but
So saying, no, that concludes his answer. He did not. Next question.
Did you review the use of force in this case at all?
I believe I signed the response to resistance form as a lieutenant.
Okay, and what is a response to resistance form?
Response to resistance form, whenever anybody resists the police or fights with the police or struggles with the police, we document what they did, what our officers' reactions were, whether they sprayed OC spray or used a baton or verbal commands or firearm display, or taser display or taser use. There are it's a specific form that goes over each level of force used during an incident that required police to use some level of force.
And did you review this case for the purpose of completing that form?
That's correct.
Is there a reason it didn't go through the standard procedure,
Objection.
if you're aware?
What's the question again?
If you're aware, is there a reason that this use of force review didn't go through the standard procedure?
I believe I signed the form. I believe it went through. Oh, sorry.
Okay. Next question.
So was the use of force review completed on this case consistent with the procedure at the time?
Correct.
Okay. And do you recall the day of August 12th, 2017?
Not in specifics. I was off duty and I was at home.
Okay. And are you aware of why Officer Amiott has switched shifts that day?
Objection. If he knows.
I did not know.
Okay. And what documents did you review in performing, what is the entirety of what you reviewed in this case in performing your response to resistance?
At lieutenant level, I review the report, review the response to resistance form. If I find them to be satisfactory, I sign off on it, and that's it.
And what is the standard you use to decide whether something is satisfactory?
Proper documentation. I look at the level of force used.
Objection. Oh,
I found it was objectively.
objection. Just saying.
What I'm asking you is not with regard to legal standard, but with regard to the departmental policy. Let me clarify that.
I found it.
You want to approach?
So the issue is they don't want him to say it was objectively reasonable because that's a legal conclusion. He can't offer that. But he could say, was it within Euclid Police Department's agency standards? Did Officer Amiott follow the law, follow department policy? So we'll see here. Also, here's Clyde. All right, hold on.
Okay.
See you in a second. Excuse me one moment, Judge. I just want to-
They're rubbing their bald heads together. Yes. Shree says, "Is this the first witness for the defense?" No, we are like 2 or 3 witnesses in, plus Officer Amiott himself just finished. We just finished his testimony, so he just finished being on the stand. We're in the home stretch of this, though, chat. So here we go.
Captain, when reviewing this case, is it my understanding you're measuring it against Euclid's policy, use of force policy?
That's correct.
And what documents did you say that you reviewed?
Our use of force policies of physical arrest. I found the report on its face to be within policy.
Okay, and I think we're on 18, 19. I think we're in. I'm going to show you what's been marked as Defense Exhibit 19. You could take a look at that. Can you identify that document?
Yeah, it's a police report from August 12, 2017, involving Officers Gilmer and Officer Amiott, Officer Papillo, Officer Thomas, and Officer Parkin.
Okay, and is that the report that you reviewed related to this case?
That's correct.
And is Officer Amiott's documentation in there?
Yes.
And is that his report that you reviewed for your response to resistance?
Yes. Yes.
Can you identify some of the aspects of that report or summarize the contents of that report which you thought indicated appropriate documentation?
Objection. Overruled.
It was pretty well documented. The actions of a motorist taken against the officer, the officers.
Objection. About the characterization.
I'm going to overrule it. Go ahead, Captain, and just go ahead. You may
It detailed what the motorist did, what Officer Amiott did.
And you thought that documentation was thorough and accurate?
Yes.
Okay. And I'm going to show you what previously marked as Defense Exhibit 13. Yeah, project right asked. Can you identify that document?
Yes, it's our policy for use of force and firearms.
And is that policy that was in place in 2017?
Yes.
And is that the policy you used to consider whether or not to sign off on response to resistance?
That's correct.
I'm going to show you now what's been marked, what I'm about to mark is Defense Exhibit 20. Can you identify that document?
Yeah, that's the Euclid Police Department response to resistance form.
And what is marked on that document?
Has the motorist name, is general description, height, weight, age, injuries, has officer injury checked and subject injury checked, has unarmed tactics checked and impact baton strikes checked.
Captain, excuse me for a second. I believe it's a front and back form, is it not?
Yes, it's missing on this. Yes, sure.
Just a second. It was photocopied as 2 pages and a second here. So I can
Thank you.
Be right back, chat.
Is that the complete document?
Yes, it's the back page was missing there.
And did you sign that document?
That's correct.
And does your signature represent your belief and assessment that Officer Amiott's use of force was
Objection.
in line? I can finish the question.
I'm going to sustain that. No, I'm going to overrule that objection. He signed it. He reviewed it. Go ahead and finish your question.
Does your signature on that document represent your assessment and belief that Officer Amiott's use of force is within the confines of the Euclid Police Departmental use of force policy?
Objection.
Overruled.
Yes.
In simple terms, his use of force did not violate this police department policy.
Asked and answered. Next question.
In the course of your review, did you determine that Richard Hubbard was actively resisting?
Objection.
Overruled. Sustained. Sustained.
May we approach?
You may.
Real quick, chat. You want Clyde? Well, you know what you got to do. Just saying. You got to put on the vest. You want Clyde.
One, can you identify that document?
It's a Euclid Police response to resistance form.
And what is that form about?
Refers to, appears to be the passenger in the vehicle, general height, weight, age. There are boxes checked for unarmed tactics and handcuffs on the form.
And did you find the conduct related to that form was within departmental policy?
That's correct.
One moment, Judge. If we're-
Certainly.
One moment, Judge, if I may.
Certainly.
Okay. That's it.
I may, these are two different forms. These are two different forms, Your Honor. Two different badge numbers. I think they mixed it up.
Okay.
Sorry.
No, that's okay.
If you want to review, the badge numbers are different on one form and the other.
See you, Judge.
The forms are, reviewing it again, the forms are two different forms. One is signed by badge 83, I believe. The other one is signed by badge 18. I think you just mixed them up.
The first one is for Amiott, the
The
second one.
second page is incorrect on this.
Here's the second page then.
I don't know.
Sorry. Can you verify that that's the correct second page?
Yeah, that's correct.
And does that change your testimony in any manner?
Now that I have both of them, the correct pages, yes. It is correct.
Okay, but it doesn't change the substance of your testimony that the conduct was within policy?
Yes, and it was approved by me.
Thank you. One last question. In the course and scope of your role as captain, are you aware or not of whether summons have to be approved by supervisors?
Objection. Summons.
And we'll find out what the answer is. Go ahead.
Yeah, summons is a criminal ticket, and also can refer to a traffic ticket. When traffic tickets or criminal tickets are issued, I want a supervisor to look at the ticket, make sure it corresponds with the police report, that the correct statutes are on there, and basically approve the ticket before it's forwarded to the court.
So if citations were issued in this case, they would have been approved by supervisor.
That's correct.
Overruled.
Nothing else. I apologize about that. Can we leave these up here?
Councilman Franz?
Good morning, Captain.
Good morning.
Captain, is it true that all of those documents that you indicated that you just reviewed and concluded that they were in conformance with Euclid Police Department policy were all documents that were authored by Michael Amiott?
No, I would conclude that at all. The report was, I believe, authored by Officer Kilmer.
Okay, but there's a 3-page supplement in that report from Officer Amiott, correct?
That's correct, yes.
There's a 2-page supplement from Officer Gilmer, correct?
He wrote the report. Yeah.
Okay, there's no supplement in there from Richard Hubbard, right?
No, there's not.
Okay, and you were at home at the time on 8/12/17, and you had nothing to do with this, correct?
That's correct, yeah.
Okay, thank you.
Free to write?
Yes, the video you reviewed, it contained a recording of both Richard Hubbard's conduct, Officer Amiott's conduct, and Officer Gilmer's conduct, didn't it?
Yes, that's correct.
And in reviewing this, did you have any question about Officer Amiott's integrity or honesty in his reporting?
Object, sustained.
Judge Revere approach? We
No.
had an issue with his character yesterday.
Correct.
They opened the door.
Beg pardon?
They opened the door.
I didn't ask for it.
This is redirect.
He just suggested it.
I don't think so. Redirect. Beyond the scope.
Were you just asked about whether you can rely on only Amiott's report?
No.
The state just asked you about whether you only rely on Amiott's report? You think
Um,
that was reliable?
No, they indicated that was everything authored by Amiott. And I said, no, there was other officers there that we reviewed their account of events.
In relying on Amiott's report,
Yes.
did you have any questions about his honesty or integrity?
Objection, sustained.
Nothing further.
Anything further of this witness? Questions by the jury? Thank you. You all can review it if you like.
Oh, sorry.
Captain, does the police policy exclude or protect an officer from the laws of normal citizens?
No, of course not. No one's above the law.
Is policy protected by law
Largely, yes, it's based on case law.
based on questions based on these questions?
Would Euclid Police Department have a use of force policy that was illegal?
Objection. What was the question again?
Would, just as a follow-up to that, would Euclid Police Department have a use of force policy that was illegal?
You can answer that.
To the best of my knowledge, no. Our policies are reviewed by our law director. And I'm not an expert in law, but a use of force policy is illegal. Be no use to me. I have to base it on the law, not what I believe in an incident that this person's right or this person's wrong. The law doesn't look at that because it's subjective. The law looks at what is legal and what is illegal.
Question? You may step down. Thank you. You may call your next witness.
That was a really good witness for Amiott, I think, at the end of the day. A very good witness. I think that was very helpful. But we've still got a couple more to go, including Officer Dorito.
We call Officer Dan Carino.
Officer, please remain standing.
Same.
And box, raise your right hand. In this matter, officer, do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. See.
If you would, officer, state your name and spell your name, last name especially, and then give us your assignment.
My name's Daniel Fito. My first name is spelled Daniel. My last name is spelled Ferritto. And I'm a patrol officer here in the city of Euclid.
How long?
I've been with Euclid for 8 years.
8 years?
Yes, sir.
You may inquire.
Good morning, Officer Fito.
Good morning.
Can you state your current employment
I'm a patrol officer in the city of Euclid
and where were you employed in 2017?
with the city of Euclid Police Department as a patrol officer.
And how long have you been with the city of Euclid?
8 years.
Are you familiar with the reason we're here, the events of August 12, 2017?
Yes, I am.
And did you make a call over the radio that day?
Yes, I did.
Can you tell us about that?
Sure. At that time, I was still am a field training officer with our department. I was training one of our new hires. Myself, Officer Amiott, Officer Gilmer, I believe, don't quote me on this, I believe we just made an arrest on the north end of the city by Lakeshore. Since I was training one of our new officers, we were taking the suspect to the jail. I was driving. The person I was training was in the passenger seat, and then we had the suspect in the back of the car. I remember it was a sunny day. The sun was out. I had my window down. I remember I was driving southbound on East 222nd Street, and a silver Hyundai had passed by us. What stood out to me was when I passed by the driver of the Hyundai, we had locked eyes. He was leaning back in the car. We locked eyes with each other as we were driving past each other. Once he saw me and we locked eyes, I noticed he had sat up. He kind of re-gripped the steering wheel with his left hand. His eyes were wide. He followed my eyes. Like we were locked in, we followed each other. He turned his head, he turned his upper body and upper torso and followed me until the back pillars basically separated our eye contact. And that's what drew my attention to the silver Hyundai, because when we're driving, I mean, you might see someone in passing, but I mean, we locked eyes, and that's what really, those indicators to me just stood out.
And did you get a call out over the radio?
Yes, I did.
What did you say?
I believe I called out that I saw a silver Hyundai going northbound on 222nd Street. I couldn't tell the exact direction of where the Hyundai went after it got by the Wendy's. I couldn't tell if it went down Babbitt or if it continued down Lakeshore. I called out that the vehicle looked fun.
What did you mean by that?
So I've been working with Officer Amiott and Officer Gilmer for years. We love our jobs. I love being a police officer. This was a dream job of mine. I love working with those guys. We did criminal interdiction together all the time, which is looking for guns, drugs, and you're always taught as a police officer, you got to look beyond the traffic stop. We're taught to see something. If you see something, say something. And if you see what's called criminal indicators, which I saw that day, that's what made me call it out. And when you see something more than just possibly a traffic offender, like there might be something in that car. Why do you look at me like that? To us, doing criminal interdiction is fun. That's our job. That's what we signed up to do.
Is it fair to say you're driving around, patrolling, you're hoping to get some guns and drugs off the street? That's why you're a cop?
Oh, absolutely. One of the things as a patrol officer, if you can make a simple traffic stop for any moving violation, if it leads to something else, if it leads to warrants, if it leads to drugs, if it leads to guns, when you make seizures like that and bring evidence back to the police department, you get accolades from your boss, you get an attaboy, you get a pat on the back, you get a good job. And to a police officer, that's what motivates us. That's what keeps us going. When you have a supervisor telling you you're doing good, and that's one of the things we have to go out there and do.
Officer Fito, you were officer here in Euclid, weren't you?
Yes, I was.
When was that?
In 2016.
And you're from Euclid, born and raised?
Yeah, born and raised in Euclid. Grew up on Meredith off of 200 Street. I moved off of Lakeshore Boulevard. I went to middle school here in Euclid, went through high school, played on the basketball team. It's my hometown.
It's been 5 years. You must be aware that that comment has been interpreted as being wildly inappropriate, correct?
Correct. I'm sorry.
Go ahead.
The connotation of that comment, it's been taken out of context, unfortunately. Was it maybe something I shouldn't have said on the radio? Sure, but our radio traffic back and forth, we're talking all shift long for days, weeks, months with each other. I didn't think it would turn into this. I didn't think it would turn into a negative connotation because there was no negative connotation on my side.
And in your time working with Officer Amiott, have you ever heard him speak like that on the radio?
No, I have not.
Nothing further.
Thank you. You may cross.
Thank you. Hello, Officer Fito.
Hello, sir.
Officer Fito, so if I understand your testimony correctly, on this day in question, you're driving southbound on 222 and there's a Hyundai driving northbound, correct?
Yes, sir.
You locked eyes with that driver, correct?
Yes.
As you're passing him, correct?
Yes.
How fast are you going?
If I had a guess, maybe 25, 30. Guess. I don't actually know.
How fast is he going?
I would assume approximately the same speed, but I don't actually know.
How far away from you was that driver of that silver Hyundai when you first locked eyes on him?
This portion to 22nd Street that I'm speaking of, I don't know how familiar you guys are with the area. It's close to the Wendy's over there and the Shore Cultural Center. So it's a 2-lane roadway in that portion. And so we were probably separation of 2 cars passing each other. So maybe 5 to 6 feet, give or take.
5 to 6 feet?
Possibly.
Okay, so you're coming at each other, and when you're 5 to 6 feet apart, nose to nose, you look at him and he looks at you, right?
Yes, sir.
And how long did it take you to pass each other? A second?
I'd say several seconds once we initially made eye contact.
Okay, so you're coming at each other 30 miles an hour, and when you're about 5 to 6 feet apart, you lock eyes, right?
No, sir. The width of our cars when we directly passed each other would have been probably about that distance. When we initially locked eyes, our cars would have been more spread out.
How far?
A couple car lengths.
Okay, a couple car lengths. And then for whatever time it takes, 2 cars traveling at about 30 miles an hour, an average of 60, right?
Yes, sir.
For however many seconds that is, you two are still locking eyes, right?
Yes, sir.
So you notice that he's looking at you because you're looking at him, right?
Yes, sir.
And you maintain eye contact with him, and you're saying he maintained a look at you, correct?
Yes, sir.
Okay. And what kind of criminal indicators did you see?
The initial eye contact in and of itself is not just a criminal indicator, but the eye contact being locked on to each other like that, the sitting up of his body, the regripping of the wheel, the turning of the head, and then the following the movement of my vehicle as he went by is not normal behavior when I pass drivers as a on-duty police officer.
So you're saying that's not normal behavior. That's from your perspective, right?
Yes, sir.
Would it be fair to say that you don't know what normal behavior is from the perspective of a 25-year-old black man? Is that fair to say?
Yes.
Okay. So it's entirely possible, isn't it, that his perspective as a citizen was way different from your perspective as a police officer that's on the prowl for drugs and money and stuff like that, right?
Yes.
Okay. So with that context, would it surprise you at all that he, to you as a trained police officer, looked a little nervous? Would that surprise you?
Yes.
Okay, so you'd be surprised by that?
Yes, sir.
Okay. And beyond that, at that time, for whatever the brief seconds were that you locked eyes with him and you maintained your lock of your eyes, did you form any specific suspicion about what that young man, 25 years old, driving down East 22, might have been up to?
I don't know what he was up to, but I know that
My question was, did you form an opinion as to what he might have been up to?
No.
Okay. Yet you called out on the radio and said, "Hey guys, this looks fun," right?
I don't believe it's like,
Oh,
hey
you didn't
guys.
say, "Hey guys."
No.
You said, "There's a silver Hyundai traveling northbound on 222. It looks fun," right?
Yes, sir.
Okay. So did you hear then immediately after that, Gilmer said, 18, copy, I'm at 218th and Lakeshore, and he turned around, correct?
I'd have to hear the radio traffic again. It's been several years. I
Okay.
don't know the exact.
So whatever the radio traffic says, it says, right?
If it's on the radio, yes, I'm not arguing that by any means.
And then did you hear Amiott say, "Yeah, I see it," or something to that effect?
I believe Officer Amiott notified me that he said something over the radio that he located the silver Hyundai. Yes.
Okay. And during that time period, did you call out to either Amiott or Gilmer, or did Gilmer or Amiott call out to you to get some information as to what you saw that might be suspicious or fun?
Oh, no, sir.
Okay. And you had a cell phone, right?
Yes.
They have cell phones, right?
I would assume so.
Okay, but none of that communication was had, right?
No, sir.
Okay. Nothing further.
Redirect.
In the course of your police work, I assume you must call out cars with people driving of all genders, colors,
Oh, yes, all the time.
and you're certainly not a 25-year-old black man.
No, I'm not.
Have you driven past probably thousands of 25-year-old black men?
Probably tens of thousands, if not more.
Happens every day, right?
Yes.
You call them all out?
No.
Was there something about Richard Hubbard's locking eyes with you that distinguished it from other drivers generally?
Yes, they're called criminal indicators. I could go through them again, but like I said, not one indicator in and of itself is a criminal indicator. There was multiple, and I'd be more than happy to go through them if the jury would like me to explain.
Well, sure, but so something about that interaction
It was different.
triggered a recognition to you that was distinct from all drivers generally, correct?
Correct.
Did it also trigger a reaction that was distinct from other young black men you drive by every day?
Yes.
And what were those criminal indicators?
We locked eyes with each other. He sat up in his car, his left hand, he regripped the wheel. He's turning his head, following me as we're passing each other, literally all the way to the point till the back pillar separated our eye contact. There was no separation of our eye contact, and it's not normal behavior when I'm driving a car. Citizens just don't react that way when they see a police officer.
And you didn't just make up this concept of criminal indicators, correct?
No.
It's a part of your training?
Yes, and I train that to our new hires that ride with me. I teach them these criminal indicators, so it's something that they're aware of.
Do your supervisors tell you to teach that material?
Yes.
Nothing further.
Counsel.
So So just so I understand, the criminal indicators that you saw were him re-gripping the steering wheel.
With his left hand, sir.
What?
With his left hand, sir.
Okay, with his left hand. So he re-gripped the steering wheel, right?
Yes, sir.
And he kind of sat up, right?
Yes, sir.
And he looked at you, right?
He stared at me.
Stared at you.
Correct.
You were staring at him, which is how you knew he was staring at you, right?
Yes, sir.
For a few seconds, right?
Yes, sir.
And what crime did you suspect him of?
There was no crime at that point in time, sir.
Thank you. Nothing further.
Anything further? Questions by the jury? You may step down. You may call your next witness.
Judge, our next witness is via Zoom.
Via Zoom.
I don't know when we would take a morning break, we're struggling to open the Zoom, so okay.
We'll take our morning break then, and we'll come back and we'll have a witness by Zoom. And of course, witness by Zoom would be the same if the witness was here. Remember the admonition, all rise.
All right, chat, we're going to skip ahead here. No lunch breaks, chat. Oh. All right, that was Mike Daniel Dorito. Okay. See, guys, this is the thing now. This is all bullshit in my opinion. That whole I was looking at him, he looked at me, and our eyes locked. Like, that's bullshit. That's getting annoying. So, no sandwiches. Nope, no lunch, chat. We're going through. We're going through, chat. There we go. Clyde's eating something. He's got another treat. Remember the ammunition. Don't forget what you ordered at Denny's. All right, we're going to switch it back to... Here we go.
Maybe seated. May call your next witness.
So the defense was called Jamie Brown.
Mr. Ron? Euclid Municipal Court is Mr. Ron. Can you enable your video?
Yes, can you hear me?
I can hear you. Can you enable your video?
All right, chat, just so you're aware, this guy is a police trainer. He trained Michael Amiott back in the day. They were able to run him down. The guy now works for, like, doing stuff with DHS, so he's working out of town, so he's going to be a Zoom witness. The audio kind of sucks, so if you guys can't hear it, we'll skip it. But anyways, here we go.
Mr. Ron?
Yes, I'm trying to work on it right now, ma'am.
Okay, thank you.
Can you see me, ma'am?
Not yet. It's here. You click on start video if you're able to find that.
All right, just click on start video, ma'am.
Click on start video if you're able to find that.
It should be on the bottom left of the screen.
Yeah, I see it right there. I clicked on it.
It should be on the bottom left-hand side of your screen. It should show a video camera.
Ask if it's
Where's this, Rosie?
So do you have a webcam on your device?
I do.
Okay. Can you try turning the video off and then back on?
On my home computer, so I snap out the webcam. Maybe that's an issue on my desktop.
Or if there's something blocking the webcam?
I have the video block off.
Then turn it back on. So there should be a red line through it. If you click that again, the red line should disappear.
I understand.
I'm going to put you in a waiting room.
And because
We call Officer Babcock.
And because things didn't work, they called a new guy. They called one of the other officers.
And we can shut that. allergies. So
Now you're
it's
right.
normal.
I'm sorry, you're here.
Going back, if we just go back a hair, you know, you see, you know, here's Fito, here is the sergeant. You know, more and more of them are hanging out as they testify, and I would argue having cops in there in that presence or in their uniforms, you know, armed up, I would argue that's an intimidating presence. I mean, if they want to sit here and be in a, you know, polo and hang out, that's fine. But showing up dressed up, I think, is an issue. I'm surprised the prosecution didn't say anything about that.
Witness Watson, remain standing, please. Sir, please raise your right hand. You swear in this matter to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Be seated.
If you would, please state your name, spell where appropriate, and give us your assignment.
My name is Kirk Papillo. It's Kirk, last name Pavkov. I'm currently a sergeant with the Euclid Police Department.
And how long have you been with the Euclid Police Department?
10 years and 7 months.
Counting days or what?
Close to it.
Close to it. All right. You may inquire.
I'm sorry, what did you say your rank was?
Sergeant.
Sergeant Papcock, good morning.
Thank you.
Good
Good morning.
Did I pronounce Papcock?
Pavco.
Papcock.
Yes,
My
ma'am.
apologies.
No worries.
Okay, sir, can you just tell us a little bit about your training experience as a police officer?
I was trained at the Cleveland Heights Police Academy, and Euclid Police Department is the first and only police department that I've worked for. So all of the training that I've received has been at this department. It's a 5-month academy, approximately a 20-week FTO period. And
Field training? FTO?
negative, sir.
What's FTO?
Field training.
That's what I said.
Correct.
Okay. Go ahead.
No, I did pass my field training.
Okay, and because the primary or the majority of your training came from Euclid Heights, is it your belief that you were
Cleveland
Okay.
Heights Police Academy.
Cleveland Heights Police Academy and Euclid Police Department?
Correct. All of my police training did.
And is it your belief that your training is consistent with the OPATA standards?
Yes.
And are you OPATA certified?
Yes.
Okay, and in the course and scope of your experience as an officer, have you had to use force?
Yes.
And did there come a time on August 12th, 2017, where you assisted as backup with Officer Amiott?
Yes.
Can you tell us about that?
Yeah. I was stationary in my patrol vehicle when I overheard Officer Amiott on the radio state that he was making a traffic stop at 228 in Lakeshore. Shortly after, I heard Officer Gilmer state that he was with Officer Amiott, which indicated to me that he had available backup and that I didn't need to head that way.
Why would each traffic stop require backup?
It's for our safety, first and foremost. It's better to have 2 officers there than 1, sometimes 3 or 4. It just depends on the circumstances. But generally, by rule, we try to have at least 2 officers on each traffic stop.
Are traffic stops dangerous?
Absolutely.
Are you trained to have a heightened awareness about the dangers of traffic stop?
Yes.
What are some of the things you're trained to be aware of?
Well, one of the things is there is no such thing as a routine traffic stop. Every traffic stop brings any kind of danger. There's really no way to predict. There are signs and things that we can look for, things that we're trained that can come up as red flags. However, even the most, if there is such thing as routine traffic stop, could go sideways very quickly. So we're always at a heightened awareness anytime we make a
What are
stop.
some of the things you are trained to look for red flags? What are those?
One would be such as a lot of movement inside of the vehicle after you've activated your lights and sirens, or if they were hesitant to stop, or if they were slow to stop. Driver behavior, such as they were perhaps hiding something or moving things around in the car, that kind of thing.
And what is your practice when approaching a vehicle for traffic stop?
I typically do a passenger side approach. For one, that keeps me safer from oncoming traffic, from being struck by a vehicle. And I also believe that it gives me more of an element of surprise to the driver. Most drivers expect that you will come to it directly to them, whereas I like to approach from the passenger side, not only for that safety issue to not be run over by traffic, but I would prefer them to not see me approaching until I announce myself.
And is that officer preference which side to approach?
Correct.
Is it fair to say there are risks and benefits to each approach?
Yes.
Okay, and what happens once you approach?
Once we approach, we generally identify ourselves and generally give the reason for the traffic stop, and then ask for proper credentials such as a driver's license, registration, proof of insurance.
And if someone hands you, based on your training experience, if someone hands you a state ID, would that indicate whether or not they have a driver's license?
That would almost always indicate that they don't have a driver's license.
Okay, and what happens when you make a determination that's appropriate to ask a driver or passenger of the vehicle?
For them to step out of the vehicle, that's up to our discretion, whether or not we think it would be safer, perhaps, to talk to them separately, or just to remove them from the vehicle. There's so many different reasons and so many different ways you can do it, but we certainly have that lawful authority to order someone out of the vehicle. Personally, I've done it where perhaps I stopped a vehicle that had very tinted windows and I couldn't see anything inside the vehicle. I may get on my intercom and say, driver, roll down all of your windows, place your hands outside, step outside the car and come back and talk to me. Instead of approaching that vehicle where there could be 4 or 5 people inside and I have no idea what they're doing, if they're armed or not.
Is it your understanding or your practice to tell someone they're under arrest when you ask them to step out of the vehicle?
No.
Why not?
There's no need to.
And is it your understanding to be required to do that?
No.
Would it create a safety risk on some occasions to do that?
Objection. Overruled.
Answer.
Create a safety risk by telling them that they're not under arrest?
By telling them that they're under arrest immediately upon asking them to step out of the vehicle.
I don't see either way. Typically, we don't need to tell someone that they are under arrest to ask them to step out of a vehicle. We're simply conducting a traffic stop and an investigation. And asking them to step out of a vehicle is just up to our preference.
Okay. And I'm going to switch now to specifically to your involvement on August 12, 2017. What was your understanding when you started there? Did you get back up? What was the next call that you heard?
Officer Gilmer called out that he was with Officer Amiott. Approximately 1 to 2 moments later, the next thing I heard was, "We have one resisting." And to me, that would indicate that they were actively fighting or engaged with a resistant subject. And when an officer asks for assistance, we go as fast as we can. Still driving with due regard, of course. So I responded with lights and sirens from the station, and I was the first officer to arrive as backup.
Okay, and can you identify just from the cell phone, just the video of you arriving?
Is that my dash cam?
Yeah.
It looks like a yes.
Okay. And what are your initial
Just
impressions?
say this exhibit that last time.
What's it Google? It states in this. For the record, just to reference states exhibit B. Can you tell me before the video, what were your then existing impressions as you're pulling up?
As I pulled up, I noticed that there was obviously the officers and the suspect in the middle of the street. There was an active fight taking place. I also noticed that there were a lot of bystanders who had circled around, pulled out cell phones, were taking videos. That's before I exited the vehicle.
Okay, and what did the observation of circumstances cause you to modify your approach in any way?
Absolutely, I went as fast as possible. I could see that they were struggling, that the suspect was certainly resisting, that they were having trouble subduing him, and I got out of my car as quickly as possible and I ran up to assist.
Okay, I'm going to play the video from the perspective of your dash cam and then talk about it.
Sure.
What are you doing here?
So as I exited my car and I ran up to assist Officers Amiott and Gilmer, I noticed that the subject who was on the ground, Mr. Hubbard, he was saying what I would call fighting words. I'd rather not repeat them unless you want me to. But he was saying a lot of expletives towards the officers. He was pushing, pulling with anything that he could. As you can see, they're kind of on the main part of his body, but he's using his feet, he's using his arms, and they're having trouble getting him handcuffed. Also, the crowd that was around was also yelling a lot of derogatory things towards the police. So at that point, it was a bit of a chaotic situation. You're not sure if someone's going to run up on you, try to pull you off you, try to assault you, and help the person who's being arrested. So the first thing I wanted to do was help them handcuff Mr. Hubbard. So as I approached, I noticed his head was up, which gives him the ability to continue his verbal tirade. He could possibly spit at the officers. Also, with his head free, it's another part of his body that he can use to maneuver. There's a thing called a bridging technique, where you can use the muscles in your neck by pressing your head against the ground to brace your body up off the ground. So what I did was, at first, I tried to take control of, I believe there was a handcuff already placed on his right arm.
No, and that would be,
That's Officer Amiott.
And you can have it right on here.
Correct.
Is there anything unusual about the way, in your mind, based on your training experience, anything unusual about this position or the way that Officer Amiott is cuffing them?
No.
And what is it? Who is this?
Officer Gilmer.
And what is he doing here?
It's hard to see from this vantage point. I mean, it looks like he's trying to get control of the left arm.
The other arm. Okay. You can continue.
So as I approach, I try to assist Officer Amiott with gaining control of the left arm. I'm unable to do so. And shortly afterwards, Officer Thomas, I believe, is the next officer to arrive. And together, we're able to get his left arm behind him and secure him in handcuffs.
What are you doing here?
So I mentioned earlier that his head was free to move. He could spit on the officers. He could use it to ridge away. So what I did was I pushed his head down towards the concrete, and then I placed my knee on his head to secure him. Now, from my experience with resistive subjects, is the more you can secure their moving parts of their body, the more likely they are to surrender to police.
Now, in this suffering, it looks like you're in a bit of a squatting position. Are you putting the weight of your body on his head?
No.
And is your knee on his head or his neck?
Head.
And is this practice in line with the way you've been trained?
Yes.
Is this a technique you're utilizing today?
Yes.
Pause it. Is this where you're assisting getting the left arm?
Correct.
Is it, so at this point, you and Gilmer are pulling on that left arm?
I believe so, yes.
What's happening here?
I mean, it's hard to see from this angle, but it looks like we're trying to gain control of his left arm, but we're not having much success.
So,
And now I've moved to holding his head down with my hand because he had worked his head away from my knee. As I stated earlier, I didn't have my full body weight on his head. My intentions were not to hurt him or apply pain to his head. It was to stabilize his body. The more body parts you can stabilize, the more likely you are to handcuff the suspect.
now, I see he was on his stomach. I see now it appears he's on the side. Is that accurate?
Yes, he's continuing to resist.
He's trying to roll back.
Correct.
Sustained.
Is that your understanding?
Yes, he was all over the place. That's the best way I could put it.
Okay, and at this point, are you moving your body to the side position? Is
I-
that-
It's hard to say. His arm is very loose and it's kind of all over the place. And I'm trying to gain control of his wrist and get it behind his back. But at this point, he's continuing his verbal tirade, which I would describe as fighting words. And he's continuing his physical resistance, which is everything in his power to escape our custody.
Officer, you appear to be a fairly fit guy. So you actually, I mean, for a guy very strong, correct?
I would agree with that.
What do you weigh?
210 pounds.
We heard testimony that Mr. Hubbard was about 160 pounds. Does that sound right?
I would believe that, yes.
Can you explain to us why you had such a hard time getting one of his arms under control,
Objection.
given your size difference?
Yeah, we described it.
Beg pardon?
We already described it.
He did describe it. He
State
did.
made issue of
Oh,
stop.
You may answer it. Go ahead. Answer if you can.
I would say if you speak to any police officer, some
We're
of
not speaking to any police officer. We're talking about you.
Thank you. From my experience, some of the most difficult people to bring under control seem to be some of the smaller people. Size does not necessarily mean strength or will. Obviously, the adrenaline is flowing. It's a matter of will and adrenaline, and some of the smallest people can be some of the most difficult to detain.
So it's not, was this an uncommon experience that even larger officers have a difficult time handcuffing or subduing this driver? I'm not even done with the question.
Here we go. I already answered it. But you, me and the jury will leave if you all want to talk to each other. Sustained. Next question.
What was the basis for that?
Lee, next question. You know that.
Is this the first time you've had this difficulty?
No.
Is it common?
Yes.
And as far as you know, is your experience consistent with other officers' experiences?
Sustained. Next question.
Have you used other resistance occasions in which larger officers needed backup to subdue a smaller subject?
Objection. Sustained.
What is the basis of that?
Sustained. Next question.
That's what I'm sorry. Awesome. What did we just see here?
That's Officer Thomas going to help.
And at this point,
We still haven't applied the second handcuff.
okay, Officer Thomas is here.
Correct.
Who's this?
That's myself.
Who's this?
I believe that's Officer Gilmer.
And we have you in the mount here behind.
Yes, ma'am.
Okay. Pause it. At this point, there's 4 of you here, correct?
Correct.
And this is second handcuff yet.
I can't confirm, but I believe it's very close to being completed, the second handcuffing, yes.
Okay, pause. What did Officer Amiott say to you?
So from my recollection, once that second handcuff was applied, Officer Amiott directed me to arrest the female in the street, who I believe is Yolomar Tirado, is that correct? Yes. Okay. So as soon as that second handcuff was applied, he, as you can see, he points directly to her and he simply said, arrest her.
And you did that?
Correct.
You think that was appropriate?
Yes.
Okay.
In a chaotic scene like that, where I only have the knowledge of what I have observed, I trust my fellow officers that they have, whether it be reasonable suspicion to detain someone or probable cause to make that arrest. It's not my place to second guess that officer, especially with the chaos that was going on. And from what I picked up initially, as you can see, she's in very close proximity to those officers. So in my mind, I was not sure if she had interfered with the arrest, such as trying to pull the officers off of the suspect, or if she had assaulted the officers, or if she had committed some other type of crime. But she was certainly much closer than we would prefer to have someone when we're trying to effect an arrest. So it seemed reasonable that the order that he, I wouldn't call it an order, but what he asked me to do.
Okay. And when you're arresting her as part of that instruction, tell us about that.
I approached her. I told her that she was under arrest. She backed away. She began to back away. I believe she said, "Don't touch me." I could tell that she was very emotional and distraught. I took her by the left arm and began to use kind of a left arm bar technique. Again, trying to use the least amount of force as necessary. And I guided her to the ground.
Is that what we're watching now?
Yep. I'm basically telling her to relax, put her hands behind her back. She's pulling away, and I kind of pull her to the ground. And that's Officer Thomas who comes in, begins to assist me. And at this point, she stopped resisting, and now handcuffs are applied. Once she had gone to her stomach, she had stopped resisting.
Okay, and has this use of force been subject to review?
Yes,
As far as you know, has it been determined that your use of force was within your departmental policy?
yes.
Any further?
Thank you. You may cross.
Good morning, Sergeant Pepper.
Good morning.
So, Sergeant Pepper, when you arrived on scene, you said that Mr. Hubbard was on his stomach, right?
Yes,
He was yelling profanities or expletives, correct?
correct,
You went over to him and you placed your left hand on his head and pushed it down, correct?
correct.
You then put your right knee on his neck, correct?
I think it was my left knee,
Your left knee on his neck area, correct?
negative, on his head.
His head. And is that depicted in the video?
I believe so, yes.
You put some pressure on it, right?
Just enough to keep it stabilized,
You
yes.
put some pressure on it, right?
Yes,
At any time, did you see Richard Hubbard punch, strike, or attempt to punch or strike any police officer on scene?
no,
At any time, did you see Richard Hubbard spit or attempt to spit at any police officer?
no,
Okay, I'm sorry. At any time, did you see Officer Amiott punch Richard Hubbard one time in the head with his right fist?
yes,
Nothing further.
Redirect.
Yes, that's okay. Is punching or striking the only metric for resistance? I guess metric, I mean, the only way you measure resistance.
No.
What are you looking for when you see resistance?
I'm not sure I understand the question. What am I looking for when I see resistance?
Well, what besides punching and kicking, what else constitutes resistance?
Objection. Here, testify.
Overruled.
Resistance is attempting to escape, would be one. Resistance is verbal, it's physical, it's mannerisms. All people have to do is stop their resistance and allow the handcuffs to be placed on them, or they could state that I'm done and also follow that up by complying physically. Many times they state I'm done, and that's more of a trap in which they try to escape. But at no point did he stop resisting during that incident.
And you don't have to wait. Officers aren't required to wait until someone punches them to respond to resistance, are they?
No, we generally use one level higher force.
Are you familiar with the response that use of force continuum in the Department of State Euclid?
I am.
Is this consistent with the use of force continuum in your department? For this model? My first.
You may.
Thank you.
Exhibit.
10. Showing the witness with remarks dispensed through the 10. Is that your use of force continuum?
Yes, this is how I was trained.
Okay, and based on your training, if someone is pulling away from the officer,
Yes,
you can strike muscle groups, takedowns, joint manipulations, or pressure points, correct?
correct.
And if someone is wrestling with the officer or pushing with the officer, striking, punching, kicking, aerosols, electrical devices, or batons, correct?
Correct.
And if striking or kicking the officer, baton techniques or vascular neck restraints, correct?
I don't believe we any longer teach vascular neck restraints, but at the time, that was part of the training,
In
yes.
2017.
Correct.
And as far as you know, no one here used vascular neck restraints or baton, correct?
That's correct.
And when you made the decision to use a takedown on Ms. Carvalho, did you
Yes,
testify she was pulling
Hold
away?
on. Sustained. Behind the scope.
You testified in cross that you saw Officer Amiott punch Richard Hubbard, is that correct?
Correct.
Based on your training experience, did you know why he punched him?
Objection.
Sustained. Rephrase if you wish.
Based on your training experience, was there a departmental policy which guided that punch?
Objection.
Sustained.
Was he handcuffed at the time that he was punched?
I believe there was one handcuff on.
And did you recall what happened once he was punched?
I believe we were then able to gain control of him. It was effective,
It was effective?
yes.
And did you see anyone use any force on Mr. Hubbard at all after he was handcuffed?
No,
Nothing further.
Anything further with this witness?
No.
Jury questions, any? You all keep giving me these little pieces of paper. They need to be a little bit bigger. Thank you. I'm going to ask the question. Is using fighting words a means to use more force to gain compliance if there is no other form of resistance?
It's certainly an indication that
That's not the question about indication. It's fighting words. That means, does that give you a basis to use more force to gain compliance?
Yes, everything is
if there's
resistance.
no other form of resistance.
I would say yes.
You would say yes. Okay. All right. Anything based on that?
If someone is using expletives, swearing, or calling you names, but is physically compliant, can you use force on that?
Objection. Okay. Overruled.
If they are not doing anything towards like advancing towards you
No,
or
they're physically compliant. That's officer, arrest me, but they're about to be named.
as police officers, we kind of give a pass where that goes, unless it's in a public place, then, well, that's criminal charges, but no, I would
No, it's still not disorderly conduct. You have to take it.
not use force for someone who is just using verbal language towards me. Only verbal language.
Is aggressive verbal language when paired with force an indicator of intention?
Objection. Sustained. Counsel, next question.
I just want to rephrase.
Rephrase that.
When you are perceiving an event to determine the appropriate level of force, does the subject's fighting words, when paired with their resistance, indicate their intent to continue resisting?
Objection. From his perspective, answer the question.
Yes.
Anything else?
No.
Anything? No. You may step down. Thank you. Are we ready to try Zoom, or do you have another witness? Why don't you see if we can get it going?
Guys, please don't do spoilers. No spoilers, chat. We'll talk about what happens later.
During these pauses, you all can talk to each other or what have you. You all, you don't have to be talking to each other. If you would, please state your name for the record.
Just my name is James. That's Hubbard and Amiott. I'm the third of the Department of Homeland Security, the DC region. I'm a federal law enforcement instructor, and my title is law enforcement specialist.
All right, chat. If this gets to be too crappy for you guys to hear, like I've listened to it before and it's okay. If you guys can't hear it, we'll skip him and move on to the last witness who's in person.
Conducting this examination over Zoom, so I want you to really be attentive and ensure that if objections are made, etc., that you do not respond until after the court has had an opportunity to make a decision. Do you understand?
I do.
You previously testified in court, correct?
I have one.
Very good. Counsel, you may proceed. Oh, please spell your last name, sir.
Yes, Your Honor. Last name is spelled
Okay, it really doesn't get much better than this, guys. So, do you want real quick chat? It doesn't get a whole lot better than this. Are we good to skip them? What I can tell you is James Rumpf, he is a trainer. He trained Michael Amiott. He remembers training him back when he was a brand new police officer. So he trained him in a lot of the information and tactics. So you guys want to skip? All right, we'll skip. We'll skip. And we go into like the next actual video here.
Critically
So, yeah, he keeps going here. And then they have the final witness. So.
Council approach. If you would, please state your name for the record. And your position, sir?
I'm a retired law enforcement officer, currently working as a law enforcement trainer, consultant, and
You brought a photo with you.
I'm sorry, a photo? I have a folio, yes, Your Honor. I have my written report.
You may proceed.
Good morning, good afternoon, Mr. Davis. How are you?
I'm well, Counselor, thank you.
Can you talk to me first about your experience as a law enforcement officer?
From 1982 until 1990, I was deputy sheriff with the Summit County Sheriff's Department. In 1990, I was hired by the Akron Police Department, and I worked at the Akron Police Department, a variety of assignments until April of last year when I retired.
Okay, and what is your education and experience as a police trainer?
I originally went through, my background was elementary education. My family are teachers. And when I hired in the police department, I had an interest in the training of police officers. So I paid my own way and went through what they call instructional skills training to learn how to be certified as an instructor in the state of Ohio. And then that was around 1982. And since then, I've continued to keep up on my professional training throughout the years, mostly self-funded.
Did you receive the Attorney General's Distinguished Training Award in 2018?
I did.
And did you receive the Summit County Prosecutor Top Cop Award?
Yes, I did.
And in 2019, did you receive the National Law Enforcement Hall of Fame Trainer of the Year Award?
Yes, I was inducted into the National Law Enforcement Officer Hall of Fame.
Mr. Davis, are you certified in Force Science Institute Force Analysis?
I am, yes.
And are you certified by the Federal Law Enforcement Training Center?
Yes, I've gone to FLETC, as it's known, for both non-deadly use of force instructor program and multiple firearms instructor programs as well.
Are you a certified instructor for OPATA or the Ohio Police Officers Training Academy?
I think I still have old certification on OPATA. I haven't been teaching in basic academies in a few years, but I was a certified instructor. And furthermore, I worked for OPATA, which is the Ohio Peace Officers Training Academy in Richfield, Ohio, for a number of years as what they call an adjunct instructor, which means that I came in and taught courses for them.
Are you a member of INETA?
Yes.
What is that?
That's the International Law Enforcement Educators and Trainers Association.
Mr. Davis, you trained for the Department of Homeland Security in use of force?
I originally went through training for the Department of Homeland Security and was certified as an instructor. I think what you might mean is after 9/11, I was one of a cadre of instructors that taught Delta Airlines and violent passenger management.
Sorry, I might mix that up. And do you write articles in national publications about use of force and policing?
I do. Unfortunately, most of the magazines have gone out of business over the years. People don't read that much anymore, unfortunately. But I did, and I wrote online articles as well for Police One, Law Officer, Officer.com, a variety of other online portals and periodicals.
Have you authored any books on this subject?
Yes, I written a book called The Use of Force Investigations, a manual for law enforcement.
And Citizen's Guide to Armed Defense?
That's correct. That's more in the private citizens' use of firearms in self-defense.
Have you trained officers in use of force?
Yes, both the basic academy level at the Akron Police Department, the University of Akron, Kent State Police Academy, as well as in-service training for the Akron Police Department, where I was assigned to the training bureau for about 19 years. I was the primary use of force instructor.
How about traffic stops and approaches?
Yes, I was a certified instructor in what's called the STOPS program. So I taught vehicle stops and approaches.
Building searches?
Correct.
Use of force for a frontline supervisor?
Yes, I actually developed that course and began teaching it for all the supervisors of the Akron Police Department.
Firearms?
When I retired, when I left the police training bureau for about 3 years, I was assigned to the body worn camera unit. But prior to that, I was the senior firearms instructor for the police department.
SWAT tactics?
Yes, for 12 and a half years, I was the lead instructor and team leader for the Akron Police Department SWAT team and taught monthly training program to the SWAT team members as well as in basic academies.
And I'm just going to go down the rest of the list. Prisoner booking and handling, positional asphyxia, evaluating, managing police use of force legal standards, female officer survival, and rapid deployment. Those are all topics you've been certified to teach in and have experience teaching in?
Yeah, I either taught in-house for the Akron Police Department or in courses for the Ohio Peace Officers Training Academy.
So it looks like your curriculum vitae lists probably 100 articles you've drafted. Would that be a fair guess? Maybe more?
I think it's under. It actually is more than 100, but it's hard to keep track of.
Okay, and it looks like, have you been certified as an expert witness in use of force and use of force investigations?
Yes, actually throughout the United States, I testified in municipal courts in Ohio, common pleas courts throughout Ohio and Virginia. I have also been certified as an expert in the 10th Circuit, which is out of Denver, and here in Ohio in the 6th Circuit.
And in addition to circuit courts, have you testified in district courts for Ohio's Northern and Southern District and federal court?
Because I currently have cases in both the Northern District and the Southern District of Ohio.
Did we move to have him recognized as an expert?
Any objection?
No objection.
The court will recognize Mr. Davis's ability to opine in this case. You may proceed.
Thank you.
Mr. Davis, if you could just describe what a use of force expert or analyst does. What is your role?
Well, it's multifaceted. The use of force expert comes in much like a forensic examiner after the evidence has been obtained by the local police department, after the investigation has been done, hopefully an investigation has been done by local PD. And we go over the materials that were supplied. I'd love to say that we always get everything on every case, but that's simply not true. It tends to trickle in, and oftentimes we miss pieces of paperwork, et cetera, that are not provided to us. But we examine the paperwork. In almost all cases nowadays, there's some element of digital video evidence, so we review that. What I do with that type of evidence is introduce it into several different video analysis tools that I have and take a closer look at the video, break it down, frame by frame if necessary, and then go over witness testimony. Any evidence that we have are provided in discovery.
And in your experience as an expert, have you provided your expert opinion on use of force to prosecutors?
Yes, I currently have cases in Ohio in which I'm working with the prosecutor's office. Usually these are high-level cases, for instance, murder cases. I'm working in both Portage County. I've worked in Summit County before, and different counties in Ohio.
And also defense, have you provided expert review services for defense as well as prosecution?
Yes, for law enforcement officers as well as private citizens.
Now, I'm rendering an opinion. Is your opinion always consistent with what the party wants it to be?
No, that's not part of the deal. What happens is an attorney usually reaches out, representing the defendant, or a prosecutor reaches out and asks me to consider the case, and if I'm interested, they then provide me materials of the case, and I give original verbal assessment or verbal opinion, and oftentimes that's not in keeping with their wishes to further retain me, and I don't accept the case, or they don't go forward with retaining me.
Okay, so someone can't just hire you to get you to say what we want you to say, right?
No.
In fact, your credibility is built on the fact that your opinion is what it is without regard for how it affects the parties.
Correct. I look at the facts of the case and make a determination or offer an opinion based on the facts of the case as applied to the law.
And at some point, were you asked to review the use of force in this case?
Yes, originally, I was retained by the the FOP in Euclid it was part of an internal discipline case. That was my original contact with this case. Subsequent to that, when there were criminal charges that were made, then I was retained by the Ohio Labor Council to work with you in defense of Officer Amiott.
Would it be correct, I said that Euclid Officer David Trent initially contacted you?
I think that's correct. That's the FOP president, if I'm not mistaken.
Okay, and in reviewing this use of force matter for the Euclid department, what materials did you review?
Well, originally it was of course, the videotapes. There were several different videotapes that were offered or submitted, and then as the case transitioned from an internal discipline case and went into a criminal case, more interviews were done. For instance, a videotaped interview from the Clark County Sheriff's Department of both. There was an audio tape of Officer Amiott and a videotape of Mr. Hubbard made. There were other paperwork that was provided, including paperwork from the disciplinary hearing and disciplinary process.
Okay, so as you sit here now, do you've reviewed all the substantive relevant materials related to this use of force?
As far as I know, yes. Once again, I can never guarantee that I've seen everything or everything was offered. But everything that was given to me, I reviewed.
Okay, and you referenced a disciplinary hearing. Officer Amiott was disciplined for his
Objection.
force.
Objection. Sustained.
Before we go through the video, I'd like to talk to you about the standard you apply in making determinations about use of force. When does an officer have an appropriate objective for taking action for using force?
Well, the use of force is based on the officer's perceptions. Those perceptions can be physical perceptions. In other words, he can have his hands on a subject and feel what we call resistive tension, pulling away, pushing, and it can escalate through actual assaultive behavior, such as pushing, throwing blows, kicking, wrestling, that type of stuff. So at those points, based on the officer's perceptions, we can go from everything from a passive resistor. For instance, an officer pulls over a DUI subject or a subject under the influence of alcohol, and based on weaving, for instance, at night, and the officer asks the subject to get out of the car, and the subject refuses and latches onto the steering wheel. That would be called passive resistance, or using their weight and not getting out of the vehicle. At that point, an officer can put hands on and use force. And as things escalate, usually the subject resists or acts or assaults, and the officer responds to that behavior. So it could be everything from that to a subject trying to kill the officer with a gun or a knife.
Mr. Diggs, do you have your report in front of you?
I do, yes.
And did you make any kind of finding or opinion about Officer Amiott's objective for taking action in your report?
I did, yes.
And what was that?
Objective. Is it written there?
It is.
May I see it?
Certainly. It's about the fourth paragraph down, Your Honor.
Do you have your report back there, Mr. Davis?
I do.
Great. What in reviewing materials?
You can You review your report, but of course your testimony is your testimony to the board. It's just for you to use if you need to, you understand?
I do understand your, I think you may proceed.
In your review of materials in this case, did you determine whether or not there was, or what was the basis for the stop here?
I think there were actually a couple different reasons for the stop, actually three, that Officer Amiott had received as other officers had a radio broadcast about a vehicle traveling on Lakeshore, was number one. Number two, that the registration of the vehicle was run and came back to an owner who was had a suspended driver status. And number three, that at the corner of Lakeshore and 228th Street, however you guys say it, 228th Street, failed to make a complete stop on a right turn.
And did you opine whether Officer Amiott had authority to make that stop?
Certainly, he's a certified law enforcement officer in the state of Ohio and commissioned in the city of Euclid, and he has the full allowance of the law to make any traffic stops based on observable traffic violations within his city.
And based on your observation and your review of materials here, did you make a determination whether those judgments by Officer Amiott were reasonable and appropriate?
Objection.
Appropriate, I'm sorry.
Objection. Objection. Can we approach?
Based upon your review, do you agree that or not agree that the actions taken by the officer were within the standard? Do you agree with that or disagree?
That they were within the standards, best practices and standards of law enforcement officers in the state of Ohio. Yes.
Next question.
What, in your review of the materials in this case, did this begin as a routine traffic stop?
Law enforcement officers, and especially trainers, don't use the term routine traffic stop because we never know when a traffic stop is made who the driver is. It could be somebody that has committed a crime you don't even know about. It could be traffic related. We would refer to those types of stops as an unknown stop, not a routine stop.
Okay, and were there aspects of this stop which you believe would have heightened risk awareness related to the stop?
Objection.
Sustained.
Can you talk to us about what are circumstances that are tense, uncertain, and rapidly evolving? How would like to use of force?
These are one of what's called the Graham factors. One of the things that we determine in law enforcement were governed by a Supreme Court decision called Graham versus Connor, and it applies the Fourth Amendment to these types of events. A stop based on reasonable suspicion or probable cause, in this case, that a traffic offense was committed. And under Graham, we have different, not an exclusive list, but part of that is circumstances that are tense, uncertain, rapidly evolving. So those circumstances, the more tense, the more uncertain, and the quicker things that transpire, the more force theoretically an officer could use.
And in a general sense, what kind of circumstances would heighten awareness of risk?
Well, obviously, the biggest one is the presence of a weapon. If the officer were to go up and see some type of weapon, been on traffic stops, for instance, where you see the butt of a gun sticking out between the seats or from underneath the seat. Also, I worked 6.5 years for the street narcotics unit, and the presence of narcotics or presence of illicit drugs tend to escalate an officer's awareness level and concerns about what might be in the vehicle, et cetera. So in this case, it was, from what I understand, Officer Amiott smelled marijuana in the vehicle.
Okay, and that would have taken it from an unknown risk traffic stop to a known risk traffic stop?
No, it's still unknown because at that point in time, until you have ascertained, what's going on, you can't assume the negative.
What is the effect of when an officer receives conflicting information from a driver, for example, in this case?
Well, oftentimes when you're stopping violators, people are nervous, of course, and you have that aspect of it. But you also have, unfortunately, a lot of drivers that do not have valid driver status. That's a concern. Of course, once you smell marijuana, that it may be some type of user, which is a simple, may not even rise to the level of assumption.
Luke, the issue here is this is not a self-defense case. They're not claiming self-defense. They're claiming the justification is that Michael Amiott's a law enforcement officer. They are not articulating self-defense. If Michael Amiott had never testified, the state would still have the burden to disprove, prove their case beyond a reasonable doubt. So even the defense has argued this is not a self-defense case.
up through a traffic or somebody that's trafficking marijuana. So you simply don't know.
Okay, you want to put the video on? Maybe with this up, Judge.
You may. And then, do you need anything? Can we assist?
No, I'm just a little warm.
A little more?
Yeah. I get more. Sorry, apologize.
Okay. Okay. You may proceed.
Moving through this, I just want you to let us know when to stop, and then I'm going to ask you to talk about what you see that makes an impression on you as a use of force analyst. Okay?
Sure.
Technical difficulties, maybe?
Hey, I'm going.
I didn't audio out of it.
She altered it. She altered it. It's not usable anymore. No.
Good.
Okay, where's the audio problem, yeah?
Why don't we take our afternoon recess?
Sorry.
We'll take it till 3:15. Remember the admonition, we'll just go over information. All right?
Okay.
You can see. You may proceed, Tom.
You go.
Hey, I'm going. Good. Hey, Rich Norris said, like, you stop by yourself, right? You got to keep all up here. So I can do your own thing. Yeah. Did you find your name or what? Is your name? What are you going to want? Are you put out for a rocket?
Counselor, if you could.
Conduct, yeah.
First of all, as an expert,
Objection. Okay, just testify, you don't need to say anything. Okay. Go ahead.
what I do in an assessment of a use of force, especially where there's digital video evidence, is understand that the video camera, in this case, the dashboard camera, is not seeing what the officer is seeing. In other words, it's a two-dimensional image taken from a certain distance and a certain angle. We cannot see the passenger compartment, and those personal observations of the officer are so important at the original approach. Signs of nervousness, evasive behavior, furtive movements, all these types of things are observed by officers when they make contact with the driver or with the passengers of a vehicle. So in this case, the video is not the representation, an accurate representation of what the officer is seeing at this time.
Okay, thank you.
That's it. All right, that's it. Here's how many you know, you're one.
Okay, if you can pause it.
What's going on here?
Well,
I'm sorry, what's going on that's relevant to your consideration in license case?
licensed drivers in the state of Ohio are required to carry their driver's license on their person.
Okay. Okay.
That is no OL or no operator's license on person is an arrestable offense in the state of Ohio. So here we have a case where the subject does not have or does not present an operator's license when asks, and then provides a state ID card instead, which would indicate that at that point he either doesn't have a driver's license or doesn't have it on his person.
Okay, thank you. Is there anything about one officer calling a car out to another officer that's relevant to your consideration?
No, this is good proactive policing. This is what we want officers to do. We get guns and we get narcotics. We arrest people with warrants on standard traffic stops, and this is part of proactive policing.
Okay. Was there anything else about this?
No, the officer had asked for the car keys, and these types of situations where you're uncertain or an officer is uncertain about the circumstances, getting the car turned off and the keys separated are sound tactics.
Based on your training experience, your expertise, is it in line with police practice and policy to announce to someone that you may be arresting them before you ask them to get out of the car?
It's based on circumstances. There's no bright line requirement that an officer has to tell a subject they're under arrest. Matter of fact, in my experience, especially working street narcotics, was that we got control of the person first, handcuffed them, and then announced what the charges were for, what they were under arrest for.
Before I ask you a more general question, what is your understanding of the police practice keeping someone inside the vehicle door?
This is used by a lot of officers. Personally, I never cared for it because the problems with it are that you have an unchecked area that's in close proximity to the driver that may have weapons in it, etc. So I never liked doing it, but it's done a lot on the street nowadays. I don't think it's taught in academies. You say cuffing in the V. In other words, to get the subject so that they can, their mobility is reduced, so they can't really run away from you, which is probably the biggest concern on most traffic stops of this nature.
So though not your preference, the purpose of this technique is to keep the person contained.
Yes, and there's some good officers that use this technique, and their primary reasoning, from what I understand, is to reduce the mobility of the driver.
Just go back like 2 seconds and go back. So, I just asked him to go back a couple seconds as Mr. Hubbard steps out the car so we can replay it slowly. Yes, we can. We'll figure it out. What do you think here is relevant to your analysis of this matter?
Well, in police work, we have a standard practice called the reactionary gap. The understanding is that when subjects get close range to you within touching distance, that they can assault you before you can react and respond. So what we see here is the violator taking steps into the officer as he steps out, and not just pivoting or turning away from the officer.
Okay, and how do you categorize that in terms of, is that resistance? Is it
Objection.
Oh, I think that in law enforcement, we have these things called warning signs, danger signs, pre-attack postures, etc. All those things are nonverbals that an officer has to consider when dealing with someone. Sometimes a person can smile at an officer, close the distance, and punch the officer. So they could say something that's not congruent with their body language. So we have to pay attention to the body language at this point. And the subject moving into an officer is obviously cause for concern, especially when you're trying to get them handcuffed if you place them under arrest.
Do you recall what's being said at this time by the driver passenger?
It's very hard to hear because there's this pinging in the background. What I understand from watching the videotape of the interview with Mr. Hubbard is that at some point he was trying to.
Without referencing a specific source, what information did you rely on in making your opinion?
Well, the statements of the involved officer as well as the statements of Mr. Hubbard.
And after reviewing all the materials, what is your impression of what was happening here?
At one point, Mr. Hubbard was trying to say that he was driving under suspension and was trying to get money to pay for, FRA suspension or pay off a suspension of some sort. But the officer's statement is that he felt that
Objection. Prepare statements, Your Honor. Objection.
The officers testified, and so is Mr. Hubbard. You may proceed.
that the officers, Amiott, perceived this movement into him as an aggressive movement, a shoulder bump or something like that nature.
Objection. He wasn't here first testimony. Objection.
Well, the jury has heard that. You may proceed.
Okay, and if a passenger in the car had said, "Don't fight," how would that affect an officer's perception of what's happening?
Objection.
Sustained.
How do, are the verbal statements of the subjects in the car, the subject being arrested, are they relevant to an officer's consideration of what's happening and why?
This is totality of the circumstances, and everything that the officer perceives, hears, feels, all that is part of his perceptions of what's going on by the suspect, by the people in the vehicle. So yes, that would be a factor.
Okay, and I want to press my hand.
If you can pause.
Pause it.
This movement, officers have to be concerned with the subject's hands, specifically what's in their hands and what they can get in their hands to attack an officer. So when an officer loses sight of the hands, or when the hands go specifically to the waistband area, that's a serious concern of the officer.
Why?
Because at this point in time, Mr. Hubbard had not been patted down for weapons. And the majority of subjects on the street carried weapons in the waistband area or in their pockets. And until he has been patted down or searched and is sure to be free of weapons to the best of the officer's ability, we have to keep the hands away from the waistband area.
Based on your expertise, are officers trained to proceed as if there could be a weapon until they know for sure there's not?
Objection.
Can you read the question again, please?
Based on your expertise, are officers trained to proceed as if there could be a weapon, even if they are not sure there is not?
Unfortunately, as evidenced by the assault of officers throughout the United States with weapons, this is a serious concern, and it's part of officer safety. Far too many officers are shot and wounded or shot and killed because they don't think about the presence of weapons and keep the suspect's hands away from those areas on the body that are commonly used to secrete weapons.
Mr. Davis, what was the question?
The question was, is officers proceed as along the lines of whether there's a weapon present?
And your answer is?
Yes.
Thank you. Now, does any of Mr. Hubbard's conduct at this point give rise to use of force
Objection.
based on your training, experience, and expertise?
Objection. It's an opinion on reasonableness, Your Honor.
Answer the question.
Yes.
And what is that?
It's at this stage when the subject's has bumped into the officer and the hands go to the waistband. If I may, of course, handcuff.
Give me a second, please. What was the question? I'm sorry, I was getting something else now.
There wasn't a question, he was just adding. I wanted to ask the last question.
Sustained then. Is that?
Your
Next
Honor,
question. Beg pardon?
I moved to strike the hand moving to the waistband. There's no evidence of that. No witnesses has ever testified to that. Move to
Sustained.
strike it.
Your motion sustained. It'll be stricken. Please disregard. Next question.
It's testifying to his observations, Judge.
Next question.
Did you observe a hand move toward a waistband?
I saw a hand, specifically, I believe it was the left hand, come over and go towards the front center of Mr. Hubbard's body.
Okay, can we rewind that a little bit and play it again? Tell me where you mean. You were pressed right there.
Right in here, we see the subject's right hand is unseen by the camera, but the officer, from his vantage point, I don't know what he testified to.
Okay. Pause there. Is the grabbing frame of the car considered resistance based on your expertise?
Objection.
Yes, this would be more than passive resistance. This would be active, what they call defensive resistance, grabbing a hold of something similar to the steering wheel that I talked about earlier.
Okay.
In this case, we could pause it. This is a grappling situation. The problem with attempting any type of use of force by an officer is with the movement of the subject. Very hard to.
Objection. There's no question.
She had asked him to review the tape and pause it, asked him to pause it to interviewing the tape to give his stuff and everything. You may proceed.
It's very hard for an officer to deliver any type of strike or kick when the officer's moving and the subject's moving, or both. So in this case, we see kind of this grappling dance, if you will, but it's very hard to take somebody down, grab a hold of them. Very hard to take somebody down to the ground that doesn't want to go to the ground. Usually officers are taught to do some type of distraction technique. It could be a knee strike to the outside of the thigh, a knee strike to the abdomen, etc., some type of kick. But here, when the subject's moving and you're moving, very hard to generate power and deliver an effective strike.
Based on your training experiences with and expertise with police practices, what have you seen so far which would give rise to the response of a takedown?
But once Mr. Hubbard moves away from the via the doorway and begins to back up, then it is standard practice in law enforcement to take the person down to the ground, to ground under control. And you want to take their base away, take their mobility away, then you can control them and handcuff them.
Pause it there.
Here we did see an attempt by Mr. Hubbard.
Same question.
She paused it.
Okay, here, thank you.
Yes. Based on your training experience and expertise in police practice and use of force, what are you looking at here which is relevant to your assessment of this case?
Well, once again, ineffective or attempts at knee strikes that were ineffective because of the movement, and an attempt by Mr. Hubbard to grab the leg of Officer Amiott.
What is, I'm going to raise the same question with regard to Officer Gilmer.
Well, the taser was introduced in law enforcement a number of years ago, and it has led to taser overdependence or over-reliance. In other words, officers tend to taser a lot. The problem with the taser is that sometimes it's in close confines with two people grappling. Drawing a taser and implementing it is very dangerous.
Okay.
If we could stop it. And that's why. The taser operates by firing two probes out, and the probes need to make contact with the subject to complete the circuit. In this case, one probe went into Mr. Hubbard, and the other probe went into Officer Amiott. But because of that, because they were in contact with one another, they complete the circuit. The wider the circuit, the more effective the taser would be. It's a pretty wide spread. And this leads to what taser calls neuromuscular incapacitation, or NMI. Essentially what you have is the muscles locking up. This is further complicated by Officer Gilmer now going in and going hands-on, because he goes in within the arc of the probes. He's now affected by the taser, so he's now incapacitated. What you have is a subject on the ground. Mr. Hubbard is going down. Officer Amiott, from what I understand, falls, and in that process injures his right shoulder during the fall.
Objection.
Also suffers a hand injury during this time. So you have not only the NMI or the stun of the taser, but you have the injuries to Officer Amiott that affect his performance from here on out. This is a very dangerous circumstance here.
And at this point, they're in the middle of nothing blocking the traffic. Is that my understanding?
Well, common drivers not paying attention, I would say yes.
So, pause it. You're understanding, based on your training experience and expertise in use of force, including taser, would two people who are tased by one trigger pull feel effects for the same amount of time?
Yeah, if you're within that circuit and the trigger is pulled, the taser is set to cycle for 5 seconds before the trigger has to be pulled again to start it up again. So yes, and if you're in that circuit in that 5 seconds, you're feeling the effects of the taser. You can pause it. I'm sorry. incident is further complicated now by the passenger, the owner of the vehicle, coming over and now introducing herself into the equation, because the officers have to split their attention between Mr. Hubbard controlling him and the potential threat of a third party that is Carabello, I believe.
Carol Dorado. I want to ask you about the series of punches or hand strikes that occurred there. Can you analyze those in the context of your experience, education, expertise, and use of force?
Objection.
What's the purpose of hand strikes?
To control a subject.
Next question.
And in your view of this scenario, is the subject in control at this point?
Objection.
Over.
No.
What factors are you looking at to make that determination?
What's the totality of the circumstances that I reviewed, and that would include the certainly the injuries of Officer Amiott as he fell to the ground, the injury to his shoulder and his hand, certainly the taser incapacitation for 5 seconds, the ongoing resistance offered by Mr. Hubbard. All those things are factored in, and we also have a question of tools and targets. What does the officer have available to try to control a subject at this point, and what tools, whether it's physical tools like fists, forearms, elbows, knees, or other intermediate weapons such as a pepper spray. So tools and targets is what we're looking at this point to affect control.
Can you identify what you're looking at as signs of resistance for Mr. Hubbard here?
I'm sorry, signs of resistance.
Right.
What we see is, although in a supine or face-up position, Mr. Hubbard is shifting his weight to the sides, and we also see his legs come up, knees come up. He's pushing with his legs and kicking with his legs.
Okay. Do you agree with me that punches are, in the view of the public, that when an officer punches a subject, from a public perspective, that's problematic?
Objection.
Would you agree that that's true?
Objection.
Read the question to me again.
Would you agree that an officer punches, in view of the public, the officer punches a subject from the public perspective, that's problematic?
Sustained.
Do you know public perception, based on your training experience and expertise, if public perception is a consideration in setting police practices and police training?
Objection.
Oh, cool. Yes or no?
Yes.
Why is that? If you know.
Objection.
Answer the question if you can.
The public oftentimes does not understand police use of force. They don't understand the legal standards for police use of force. And in that, all police use of force can look bad, even when it's, you have an actively fighting subject who an officer is trying to control. That doesn't look good.
On that, I'm going to sustain the objection, strike it, and disregard. Next question.
Has the police practices and policies, are they reviewed regularly and updated?
They should be, yes.
And does OPATA do that in the state of Ohio?
OPATA doesn't have policies and procedures, but they regularly put out information on use of force, yes.
And without regard to public perception, strikes, hand strikes, foot strikes that remain a part of use of force best practices for police and not.
These types of strikes are taught in basic academies.
Do they remain? What was the question?
The question was,
do they remain a part of best practice? I think something to that
yes.
effect.
Yes, Your Honor, yes.
Thank you.
Can you stop it, please? At this point, we do have the subject's girlfriend who's attempting to get him to calm down and not fight back.
Objection. As to his impression of what she was doing, she already testified.
Well, he's looking at the tape, so go ahead. Next question.
What was that impression based on?
Her statements, and also her statements out loud on the video.
Okay. And what are your impressions of important considerations as an expert educator who's experienced in police use of force and police use of force analysis in the last couple of seconds of frames?
Well, as time goes on in a resisting, energy depletes. Majority of police uses of force are anaerobic in nature. In other words, they're like a sprint. As a resisting goes on, officer begins to tire. After about 10 to 15 seconds, the way the body works, is that you lose about 25% of your energy stores. So time and fatigue is a factor here.
And what level of force are you recognizing? What level of resistance are you recognizing at this point?
Well, the stuns are vertical stuns, still taught in the Pada Basic Academy, in which stunning the person on the ground, attempting to stop the resistance.
Objection.
Okay, go ahead.
Sorry to interrupt you. At first, when you said stuns, I was thinking tasing. My mistake. So I just want to clarify in case anyone else had confusion. When you say stuns, what are you referring to?
There are different type of techniques taught in the Basic Academy. There's a horizontal stun, pushing or slamming a person up against a wall to stun them, or a vertical stun, the same thing on the ground. So we're seeing that vertical stun on the ground.
What is how would you categorize the level of resistance where Hubbard appears to have his arms locked around Amiott for,
Objection.
if that's what you do?
Objection. It calls for the conclusion between the testimony of two witnesses by this witness. It's appropriate.
Rephrase it.
What are you observing Hubbard doing at this point?
Grappling with Officer Amiott.
And what specifically do you observe that you categorize as grappling?
The hands are on Officer Amiott.
Okay? And what level of resistance is that based on your training experience?
This has moved up from defensive resistance to aggravated resistance. In other words, he's now actively wrestling. Well, he was actively wrestling when he was standing as well, but continued to do that on the ground.
I want to go back to where how can you tell the difference between whether he's, if you can, actively resisting or whether he's just being pushed?
The grappling positions from Mr. Hubbard would indicate he's grappling or holding on. He's not attempting to let go and just being pushed, but he's actively holding on to Officer Amiott. So that would not indicate just being passive and being pushed.
And would you anticipate that whoever is opposite Mr. Hubbard would also feel that resistance?
I'm sorry, can you rephrase?
Would you anticipate that whoever's, two people grappling, that in this case, Officer Amiott, but whoever's on the opposite side of that grappling would feel that resistance physically?
Certainly, if you're in close proximity, it's the push, the pull, that you would feel that.
And so if you weren't resisting based on your training experience and expertise in use of force, and an officer tried to effect a takedown, what would you expect to see?
The person being taken to the ground, if they offered no resistance.
Right where they are?
Yes.
You go back to where
You pause it. Talk in the Basic Academy in the state of Ohio is the mount position or the preferred position. What we see is Officer Amiott go from a side control position to what's commonly referred to as the mount. It's a safe position for law enforcement officers to be in, and they're taught that in the Basic Academy. What we see is the application of force, in this case punches. Officer Amiott is straddling, Mr. Hubbard. In this case, lesser forms of force, pressure points are not going to be effective. Pepper spray is not going to be effective because of close proximity, and so strikes are taught. You have the application of force, and usually what you have in force is an application and an assessment period, and that's what we're seeing now. So we see strikes from Officer Amiott, and then a pause and an assessment period.
Okay, I want to talk about, here's the last couple of frames. Yeah, just okay, have a quote. Is there any significance? Do we see Mr. Hubbard thrusting his hips up here?
One of the counters, and this is taught in Brazilian Jiu-Jitsu, and you see it in the mixed martial arts competitions such as the Ultimate Fighting Championship, as a bump to bump the person off the mount. In other words, they use pelvic thrust to bump the person over the top. So that's a common escape, from the mount.
To get the person off you.
Yeah, common escape when you're on the bottom and you're mounted is to bump the person off of you.
Okay.
We could pause here. Now, at this point in time, with Mr. Hubbard's legs down on the ground, he's in a supine or face-up position. Officer Amiott, Officer Gilmore have to get him handcuffed. We can see enough gap in between Officer Amiott and Mr. Hubbard, that Mr. Hubbard could roll over if he had wanted to. He'd roll over on his face.
Objection.
Can you, ask him to get down?
Sure.
Can you identify when you refer to that gap?
In this area, which is underneath Officer Amiott's pelvis, you're going to be able to see light come through, which would give a gap or distance for Mr. Hubbard to be able to roll over onto his face.
Is there any significance to the fact that his hips are significantly higher than his head?
I'm sorry.
Is there any significance to the fact that Officer Amiott's hips are higher than his head?
Well, that would indicate that he's pushed up, not it doesn't have his full weight on Officer Amiott or Mr. Hubbard, but also we have a vest carrier, so that may be part of that gap caused by the officer's body.
Okay. We were seeing different legs, and what's the significance of that to you based on your education, experience, and expertise?
Well, at the same time that they're saying roll over on your stomach, we see movement by Mr. Hubbard, but we don't see movement to roll over onto the stomach. At this stage, it seems like Mr. Hubbard is more concerned about talking than he is with rolling over and submitting to the
Objection. His interpretation. Move to strike it.
You may proceed. The jury has heard previous testimony. You may proceed.
Does the fact that someone is motivated to videotape the use of force indicate an intention to cease?
Objection.
Sustain. Move on, counsel. Away from that question. Move on.
Is there anything about that verbal exchange, besides what you just said, which is relevant to your assessment of this use of force?
No. This statement is that we can see that Officer Amiott is reshifting his weight. And if Mr. Hubbard just continued his roll, he would have been in a prone position, in a position of handcuff.
Does the positioning of the legs here, posting out with that knee, have any effect on the officer's ability to roll?
It would depend on what the officer is feeling from the suspect. I can't state what he's feeling. If he watched the video. Once again, application force and a pause and assessment. At this stage in the game, we have fatigue setting in, we have injuries, loss of handcuffs, shoulder and hand, and yet Mr. Hubbard is not rolling onto his belly to submit the handcuffing. So you have an application force strikes again and an assessment period. Just so you can back up a couple frames. You can see here by foot placement a little bit more that Mr. Hubbard is now with his toes down in a handcuffing position, but is still driving with his legs. At this point in time, the officers could grab hands. It's like they are grabbing hands. They're still unable to handcuff. The third officer arrived. With the third officer, they are finally able to get Mr. Hubbard handcuffed. You may give.
Do you see any use of force once Mr. Hubbard has both hands handcuffed?
I see strengthening maneuvers with no striking techniques. In other words, once Mr. Hubbard rolls onto his stomach, the officers are using powers, strength to facilitate the handcuffing. They're no longer striking, and that continues on through when both handcuffs are applied.
Thank you.
Thank you.
9 of your report, you talk about some important considerations about digital video evidence. Obviously, without reading your report, can you talk about what those considerations are and why they're relevant to all use of force analysis?
Well, unfortunately, it's an over-reliance on everyone on digital video evidence. We think we see something, and we don't have the full information. We don't have enough to make an assessment or analysis. We know that things can look brutal. Police use of force can be brutal, even when it's lawfully employed.
Objection.
So it's the over-reliance on video in the assessment and analysis of use of force. There are other things, compression, the speed of the video, the frames per second, et cetera, that we need to explore. But there's overall the over-reliance on the use of video in the assessment of a police officer's use of force.
On page 10, you list 10 limitations of cameras. Can you discuss what those are?
Well, specifically with body-worn cameras, they're usually about 18 inches below the officer's line of sight. In this case, we don't even have that. We have a dashboard-mounted camera that's substantially back from and at a fixed position, so it does not see what the officer's eyes are seeing. Because of the limitations of video, it doesn't feel. Video can't feel tension in the suspect's body, can't feel resistance. Depending on the angle, some action may be missed as well.
Can you talk about the concept of second guessing or 20/20 hindsight as it relates to use of force analysis?
The Supreme Court in Graham v. Connor specifically said that force is not to be judged in 20/20 hindsight.
You're on objection. Reference to the law.
Why don't you give us your answer to that reference to the law, sir?
Force is to be judged at the moment that it occurs, not based on hindsight. In other words, the question is, would a reasonably prudent and well-trained officer in exactly the same circumstance have used that amount of force?
And certainly different officers, based on preferences, may choose different types of force within the allowable range of force. Is that true?
Yes, strengths, it could be sex, male officer versus female officer, relative strength in the officer, tools available, et cetera. So, yes.
So, for example, based on the subject's level of resistance, let's say taser, hand strikes, active on all within the continuum of force. Whether one officer uses hand strikes or another uses taser, how is that relevant to the consideration of what should be used? Does the officer have to use the least resistance or the most prudent tool when choosing force in a given moment?
No, officers have a range of force options. In this case, everything from verbal control. Of course, that never stops at all. Throughout encounters, we attempt to verbalize and get the suspect to comply with our verbal orders through pressure points, stimulating, nerve pressure points on the head and the neck. Pepper spray, as you said, taser. We can fire the taser. You can take the head or the probes off and do what they call a drive stun. It doesn't tend to be very effective. You can use a baton for a different type of what they would call come-alongs. You could try to get a joint lock on there. There's a variety of different options. So officers have a range of force options and are not required to use the minimal amount of force necessary, only a reasonable amount of force.
Okay. It seems like an officer's use of force is not, the definition is not very precise. Why is that?
Reasonableness in the law is not, in the law we see things that reasonableness is incapable of precise definition or mechanical application. So the law allows an officer to use a range of force options, and that force only has to be reasonable.
At any point prior to the securing of both handcuffs, did you see anything to evidence, which is relevant to in your analysis, that would suggest that Mr. Hubbard had stop resisting.
Objection. Overruled. No, I see ebbs and flows, but I don't see compliance to a handcuffing position until he's finally handcuffed.
Does force have to be, does an officer's application of force have to be perfect?
Objection. I didn't hear the last statement. Does it have to be one?
Perfect.
Objection. Oh,
No, only reasonable.
Based upon your analysis, in light of your training, experience, and expertise, do you believe that Officer Amiott's application of force was appropriately applied in response to the resistance?
Objection.
of Hubbard?
please apply.
Based on your training, experience, and expertise, your analysis of all the material in this case, your analysis of police policy, what is your opinion with regard to whether Officer Amiott's conduct was within police policy and best practices?
Objection. Within police policies, within police policy.
Can you extrapolate on policies? Or do you mean specifically Euclid policy or general police practices?
General, like statewide general use of force policy.
Yes, that Officer Amiott's use of force was within best practices in law enforcement in the state.
Within the policy that would say best practices.
Strike practices, right? Move to strike.
Sustained. Next question.
Was within policy.
Yes.
Any other questions?
Very good.
You may cross.
Good afternoon, Mr. Davis.
Good afternoon.
Mr. Davis, we'll probably agree, won't we, that the use of force continuum is made up of an action and reaction continuum, correct?
You use the phrase continuum, so I would disagree with the use of the word continuum as applied to use of force by law enforcement officers.
When I say, have you heard the term use of force continuum? I'm sure you have.
Yes, it's no longer used in the state of Ohio.
Since when?
By APATA a number of years ago.
Define the number. How many?
10 years.
10 years ago?
10 years or more.
So you're saying in the state of Ohio for the last 10 years, since approximately 2012, Ohio doesn't use the use of force continuum?
Correct. It's no longer in the basic academy curriculum in the state of Ohio.
Okay. What has replaced it?
Graham versus Connor.
Okay. So it's your testimony that Graham versus Connor since 2012 governs all police use of force cases in the state of Ohio?
No, you have Tennessee versus Garner, and you have the State v. White. But State v. White is not in the basic academy curriculum. It will be, but it is not at this point.
All right. Is it true that State v. Garner deals with deadly use of force? Is it true that Tennessee v. Gardner deals with the use of deadly force?
Yes, the use of deadly force specifically in fleeing felons. Correct.
Okay. And Graham versus Connor applies to non-deadly force cases, correct?
Both deadly and non-deadly.
Okay. And we have here a non-deadly use of force case, correct?
That's correct.
So we agree that Graham versus Connor applies to this case, correct?
Yes.
And do we agree that Graham versus Connor basically says that the use of force that's applied by the police officer must be reasonable based upon an objective police officer standard, considering all the facts and circumstances, correct?
Yes.
And do we agree that that question is a jury question in the state of Ohio? Do you agree with that?
In addition to what's taught to law enforcement officers, or I'm not sure. But
Do you know, let me ask you this. Let me ask you this. Do you know if in the state of Ohio, in a jury trial, the question as to the objective reasonableness of the use of force by a police officer in a non-deadly force case is a question for the jury?
Objection.
Okay.
What I go do?
And this evidence, but then these questions that are being asked of witnesses is evidence, but then you as jurors will ultimately determine what the facts really are in this case. You may proceed. Next question.
Mr. Davis, in your long law enforcement career, have you been a road patrol officer?
yes, for two different agencies,
Which agencies?
Summit County Sheriff's Department and the City of Akron Police Department.
And I think you indicated that, or did you indicate that you have made some arrests for no operator's license?
I have, yes.
How many times do you think? Well, let me ask you this, sir. How many times in your career do you think you stopped the vehicle where the person had no operator's license or not a valid operator's license?
I really can't, it would just be guessing in all the years, especially with street narcotics, how many times that was done. More than 50.
Probably more than a couple hundred, right?
Counselor, I don't know. I wouldn't hazard a guess.
Can you hazard a guess as to how many times out of 100, if you stopped a person for no operator's license, would you make an arrest of that subject as opposed to giving them a summons to appear in court?
Well, at the point that they have no OL on person, even though you give them a summons later on, you're still arresting them at that point. You just don't take them into custody.
Okay, so if I understand correctly, you're indicating that if you did stop someone for no OL, no operator's license, and you gave them a citation, you wouldn't take them into custody to the jail, right?
Early in my career, we had the ability.
Answer the question.
Could you rephrase the question?
Is no operator's license, is the offense of no operator's license an offense that you would normally arrest a person for and take them to jail, or that you would normally give them a citation and let them appear in court?
You can arrest.
My question is,
but it depends on whether you could get that person into jail nowadays. That's my point. Is that
that's not the question? Listen to the question and answer the question.
The question is, throughout your law enforcement career, when you have come across a person that you determined had no operator's license, not a valid operator's license, would you more often take them into jail, take them into custody, bring them into jail, and make them post a bond, or would you more often give them a traffic ticket and let them appear in court?
Most often give them a citation.
Give them a traffic ticket and let them appear in court, right?
Correct.
You tell us that the camera is not an accurate reproduction or reflection of what actually happens, correct?
That's correct.
Okay. Would you agree that the most accurate reflection of what occurred on that scene at that time is the police officer's testimony and the other people on the scene?
Just a little bit of a
Police testimony would be a more accurate reflection of what they actually saw, heard, felt, etc.
Okay. And then do you agree that that testimony has to be assessed by a fact finder for credibility and weight? Do you agree with that conversation?
Overall.
Fact finder, can you extrapolate on that point?
A judge or a jury?
Objection.
Number one, I think given his experience and expertise, he knows what a fact finder is. Overall.
In terms of probable cause, yes.
And what about in terms of just anything that the people testified to? Doesn't that have to be weighed by the judge or the jury?
In a criminal case, we would look at probable cause and reasonable suspicion, not just overall testimony, but yes.
Yes. So you know that the event in this case happened in August of 2017, right?
I do, yes.
And when did you first get involved in this case?
I believe it was the fall of 2017.
Okay, so it happened in August. You think you got involved for the first time in like September or October or something like that?
I believe it might have been November, but in the fall.
And have you been involved in it since that time?
In different facets of it, yes.
So were you hired a number of times or just one time or what?
I was originally retained by the local Fraternal Order Police Lodge to work on the internal discipline case. Later on, I was retained by the Ohio Labor Council to work on the criminal case.
So right now then, since it's the criminal part of the case, you're working.
Translation means the Fraternal Order Police, the local, representation in the area, hired him to defend Amiott against the internal disciplinary action. And the Ohio Labor Council is, all the unions working together in the area got him together and had him retained for this.
Under the auspices of the Ohio Criminal Council?
No, Fraternal Order Police, Ohio Labor Council.
Ohio Labor Council.
Correct.
Okay, do you have a contract with them?
Contract? No.
Yeah,
What-
basically
what-
the union's funding him.
I invoice and they pay.
So you're getting paid for your testimony today?
I am.
How much do you think you were paid over the course of
I absolutely hate that because everyone gets paid. I've started to object to this because, Your Honor, everyone gets paid. When the state has a witness come up from the crime lab, do I go, "Are you getting paid for this, sir?" No, we know he's getting paid. Everyone gets paid. And if the crime lab expert sucks, he loses his job. If this guy doesn't do good, he doesn't get hired. It's not different for anybody else. I hate that line of questioning.
the last several years working on this case?
Irrelevant. He's an expert, a paid expert.
There are a lot of experts
It's tax-free,
across
bitch.
the country on use of police force, right?
There are, yes.
And I think you testified that generally what happens is you receive a phone call from somebody, and if I understand correctly, they give you some of the background information, and then you give them a basic opinion as to what you think, correct?
No, you can't make an analysis until you have the material. So usually what happens is the attorney will forward me some of the material, if not all of the material, and ask if I'm interested in the case or not. And then, that will lead to a retainer and then an oral opinion, official oral opinion.
So at the time that the person calls you, the attorney calls you, you know if they're a prosecuting attorney or a defense attorney, correct?
Yes.
And then if you indicate to them that you're going to give a favorable, let's say it's a defense lawyer that contacts you. If you indicate to the defense lawyer that you're going to give a favorable defense-oriented opinion based on whatever you review, then you tell them that, right?
Not until I've been retained, no. The attorney explains what the case is about, asks if I'm interested. If I'm interested in the case or willing to take the case based on time, then I'm retained. Once I'm retained, I review the material and give an oral opinion, but the oral opinion is not guaranteed to be what the attorney, prosecutor, or defense attorney want it to be.
So are you saying the initial part of it is a free review? Is that what you're saying?
Oh, no, there's too much material. There's volume, there's videotapes, there's reports to review, there's audio tapes of interviews, et cetera. It's too time consuming. So no, I'm given a loose explanation about the case. I say, okay, I'm interested in the case. I'll take the case, send me the material. Here's my fee schedule, including my retainer. Once I'm retained, I review the material and give my oral assessment.
Okay. So just to drill into that a little bit, I want to
We're not
understand.
drilling too much further.
I just want to understand.
We've heard it.
So is it true then that in this case, a defense lawyer would pay you a certain fee to review certain things, and then if you told them, I can help your case, they would pay you to be their witness? Yes or no?
No, I don't think that's an accurate reflection.
Okay, you said no. Next question.
Did you hear any of the testimony in this case?
No. There was a separation of witnesses, so no.
Have you ever testified as an expert where you listened to testimony of witnesses?
In different states, in Virginia, I was involved in a case where they don't have a separation of witnesses, and I was allowed to sit in the courtroom.
Okay. So do you agree that the people that are most qualified to talk about the facts of this case are the people that were there at the time?
Objection.
Overruled.
I think those are your fact-based witnesses, yes.
Yes. And you weren't there at the time, correct?
No.
So you can't testify as to any personal knowledge concerning any of the events that transpired, correct?
That's correct.
In fact, the best you can do is look at a video that you admit isn't the best depiction of what occurred, correct?
In conjunction with examining the totality of circumstances, correct.
And what would you examine besides that? Besides the video? You went through the video in this case, on direct examination, correct?
I did, yes.
You admit that that's not the best representation of what occurred, correct?
Correct.
And you weren't there at the time, correct?
Correct.
And you do admit that the best representation of what occurred is the testimony from the people that were there, correct?
Well, their statements, and their statements were gathered during the investigation, and I did review statements from both the involved officers as well as Mr. Hubbard and others that were present that day.
But you did not, did you, listen to testimony that was examined and cross-examined and challenged, did you?
No, just
That was an answer.
Move on. Move on.
You got it, one moment.
Certainly.
Nothing further.
Thank you. Read your right, Tiffany.
You asked about your experience with traffic stops. How many times, how regular would it be when an unlicensed driver is back in a car?
never.
And would you agree you will retain and authored an opinion years before this case was charged or came to trial?
Years before, yes.
And did you review interviews which were audio and video recorded of Officer Amiott,
Yes.
Officer Fito,
Yes.
Officer Papka?
No, statements, not audio.
Okay. What about Officer Gilmer?
Written statements.
Yolamar Torado Carvella.
I'm trying to recall if that was an audio tape or not. I think it was audio tape. I can't recall.
Richard Hubbard.
Yes.
Audio and video.
Videotape. Videotape.
Have you ever want to change your opinion at the request of someone's hired you?
No.
Would you ever?
No.
Turning online?
No.
Anything further this way?
No.
Questions by the jury?
This is it, chat. Last people.
You all wish to report. You heard the girlfriend in the video say they stop. Then she was arrested. Was she close to the officers or Mr. Hubbard?
Within close proximity at one point, yes.
At the time they arrested her, was she?
No, I say about 6 feet away or so.
I'm going to read this question so you understand. Is it true to say if you can't feel a police officer's bodily or other functions, you also can't feel a person being arrested function?
I think I understand that, Your Honor. I mean,
Okay.
if you're not touching the person, then you're not going to feel that resistive tension or feel that subject's movement. Yes, that would be true.
Not responsive to your questions. Questions, please. Excuse me, these questions.
So the logic applies equally. If you can't feel the subject's attention from watching a video, you also can't feel the officer's attention or movement from watching a video. Is that correct?
That's correct. If you're not in touching the person, especially when we're talking about video, you're not going to be able to feel that. That's correct.
And based on your training education experience, even though Ms. Carvello was at times trying to subdue Mr. Hubbard, is there,
Objection, sustained. She wasn't trying to subdue him, I don't believe.
even though at times she was verbally saying, stop, bang, is there a law enforcement purpose for her arrest?
As the situation would transpire, the officers would have to come up with their probable cause for making that arrest. So it depends on what the officers perceive. My focus, of course, was on Mr. Hubbard in this case.
No. Thank you, you may step down.
Thank you, Your Honor.
All right, chat. That's it. That's it. Do you guys want the closing arguments or you just want the verdict? Like, we can move on to the next phase and this will be it. You know, we can finish it all up tonight. So we can finish it all here if you want. You just want the verdict? Let's see. Hold on here. We need to do a poll. God, we got to do a poll. Okay. You want verdicto? Seller says, what's the actual law? I don't know if he's guilty or not. How long do they go on closing? How long is closing? Closing is... Let me see here. How long is closing? Closing is a total of 2 hours and 20 minutes. They go through a lot. It's a very in-depth closing. So, remember, part of that is the judge reading instructions, too. But yes, they did closing. They came back another day, and they did closing. So, it's actually like day 5. But yeah, it's like 2 hours of closing. Guys saying no thanks, no closing. All right. We'll move on to his verdict.
Didn't you yet?
All right. So, real quick here. Here's what I will say. What you guys are asking me what I thought happened here. I thought Michael Amiott was in the right. Richard Hubbard didn't want to get arrested. So, yeah. I think Richard Hubbard was resisting arrest, and yeah. Michael Amiott was justifying his use of force. So, anyway, we're going to do his verdict here. Here's the verdict.
You may be seated. Ladies and gentlemen of the jury, you've advised the bailiff that you've arrived at a verdict. Have you arrived at a verdict?
Yes, sir.
If you would, please pass it to the bailiff. Thank you. The heading in the Euclid Municipal Court, Cuyahoga County, Ohio, State of Ohio, plaintiff versus Michael Amiott, defendant. Case number 19 CRB 00890. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant, Michael Amiott, not guilty of assault, a misdemeanor of the first degree in violation of Section 2903.13A of the Ohio Revised Code, as charged in Count 1. We do so render our verdict this 29th day of July, signed by all 8 jurors. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant, Michael Amiott, guilty of assault, a misdemeanor of the first degree, in violation of Section 2903.13A of the Ohio Revised Code, as charged in Count 2. We do so render our verdict this 29th day of July, 2022, signed by all 8 jurors. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant, Michael Amiott, guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of Section 2921.45A of the Ohio Revised Code, as charged in Count 3. We do so render our verdict this 29th day of July, 2022, signed by all 8 jurors. Ladies and gentlemen of the jury, are these your verdicts?
So he was found not guilty of the first count of assault, but then after that he was found guilty of one count of assault and 1 count of interfering with rights.
Yes.
On behalf of the state, do you wish the jury polled?
No, Your Honor.
On behalf of the defendant, do you wish the jury polled?
Yes, Your Honor.
Juror number 1, is this your verdict?
Yes, it is, Your Honor.
Are these your verdicts, I should say?
Yes.
Juror number 2, are these your verdicts?
Yes.
Juror number 3, are these your verdicts?
Yes, Your Honor.
We'll get to
Juror
that
number
later on.
4, are these your verdicts? Juror number 5, are these your verdicts?
Yes.
Juror number 6, are these your verdicts? Juror number 7, are these your verdicts?
Yes.
Juror number 8, are these your verdicts?
Yes.
Anything further of the jury? Ladies and gentlemen of the jury, I want to thank you all for performing your civic duty. One of the things that I will say is that you've done your job. You came, you heard the evidence, you applied the law, you made a decision. The prosecutor had a job, the defense attorney had a job. Your job was not to prove anything or disprove anything. Your job was to determine what was presented to you, determine the facts, apply the law, render a verdict. You did that. You should leave feeling that you've done your job. No second guessing, you've done your job. If someone else did, that's not your job. You've done it. With that, you will be discharged. If you'd like to hang around a few minutes and talk with me, I will do that. If you do not, that's entirely understandable. Sometimes the lawyers would like to talk with you to determine how they came across to you. But again, that is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor.
On behalf of the defendant, anything?
Okay.
Ladies and gentlemen of the jury, thank you very much. You're discharged at this time. If you want to wait in the jury room, I'll meet with you later. With that, you're discharged. All rise.
Yeah. Six. Right.
You may be seated. Based upon the verdicts rendered by the judge, the jury, the court at this time will enter on, with respect to count 1, a finding of not guilty, count 2 and count 3, the court will enter a finding of guilty. The court will set this matter out for sentencing, given the fact that under Ohio law, the victim has the right to make a statement or present anything he may wish to present to the court. The court will request the Cuyahoga County Common Pleas Court Probation Department to submit to the court any documents or any information that it wishes to submit with respect to pre-sentence investigation or what have you. The court feels that that's appropriate, given the fact that the Euclid Municipal Court is under the judge. The judge recused himself. It is better that we maintain the appearance of appropriateness in requesting that that be done by the Cuyahoga County Common Pleas Court. Anything else, the court will consult with the attorneys and the court administrator and set this matter over for sentencing at a date that's agreeable for everyone. Anything else on behalf of the state?
Okay.
Anything on behalf of the defendant? If there was a bond or no bond, it'll continue as stated. I want to thank everybody for their conduct. I know it got a little contentious that time, but that's to be expected sometimes. With that, we adjourn.
All right.
Yes.
Counsel, would you approach, please? I'm sure.
All right, chat. Okay. So he got convicted. He ended up getting sentenced. And he got sentenced at a later date. Now, he was given 90 days in jail. They was suspended. And then very shortly after that, Amiott appealed. And this past April, almost into May, his appeal came back. No, he didn't get any jail time. So the officers in the gallery are in disbelief. I think they are. So, here's what happened though. So he appealed into the 8th Circuit Court of Appeal, or the 8th District Court of Appeals in Cuyahoga County, Ohio, and the county is so big with so much cases. This county has its own court of appeal, its own appellate district. This and Cleveland and Columbus have their own appellate districts. So my City of Euclid versus Michael Amiott. Judgment vacated. Released April 25th. Now, who did the appearances? So Dominic Vitiano, Antonio, he is the prosecutor we watched, and Kimberly Kendall Coral for appellant. So this appeal brings his appeal challenging his conviction and sentence. After a thorough review of the applicable law and the facts, we vacate appellant's convictions and sentence, meaning done, wiped out, invalid, overturned. They are vacated. Now, what's the issue here? So the problem is that on August 12th, 2017, the stop happened. On August 6th, 2019, Hubbard signed complaints against Michael Amiott for assault and interfering with civil rights. He then signed an additional complaint against Michael Amiott for assault and interfering with civil rights in another case. In both cases, Dominic Vitonio filed a notice of appearance as special prosecutor. So, the appellant filed various pretrial motions, including motions to dismiss based upon speedy trial grounds and the appointment of special prosecutor. It took almost 5 years, but on July 22nd, 25th, 6th, and through 29th of 2022, the trial was held. He was sentenced to 90 days in jail and 90 days suspended, 1 year probation, $1,000 fine, and court costs. So, when he appealed, he raised 9 issues. The trial court was divested of jurisdiction after it failed to bring the defendant to trial in 90 days. And 90 days is the speedy trial window for misdemeanors in Ohio. The trial court abused its discretion when it denied appellant's motion to dismiss the special prosecutor. The motion to disqualify the special prosecutor had a conflict of interest. The trial court erred when it proceeded on void charging documents. Prosecutorial misconduct, impugning the rights of the appellant. That it permitted testimony and arguments that the car stop was improper. It further instructed the jury in the constitutionality of car stops when the defendant wasn't charged with that. And that if it found the jury instructions on the elements of assault without any reasonableness consideration, that there was the unconstitutionality placed the burden of proof on the defendant. And the sentencing where undue delay had divested the court of jurisdiction. So there were 9 issues, and the court only wrote 11 pages. So obviously they didn't consider them all. So the law analysis, they bring up the first issue. His right to a speedy trial was violated because it was more than 90 days after the summons was served. So you have a right to speedy trial in Ohio. And statutory speedy rights in Ohio impose a duty on the prosecution when the defendant hasn't waived the right to a speedy trial. It applies to defendants and is mandatory and must be strictly complied with. Nonetheless, there are an exhaustive list of circumstances that extend time in which a defendant must be brought to trial. On a period of any reasonable continuance granted other than upon the accused's own motion. So you have to see, they have 90 days. And once the time limit has expired, the defendant has a right to get dismissal. The state is obligated to produce evidence demonstrating the defendant was entitled to be brought to trial within the 90 days. And because it was a first-degree misdemeanor, it was 90 days after the person's arrest or the servants of the summons or the complaint. The speedy trial clock began to run on August 6, 2019, when he contends he was served via his counsel with summons for the offenses at issue. The trial didn't commence until almost 5 years later. More than 90 days passed between the summons and the appellate established a prima facie case. His right to speedy trial was violated. So, guys, basically, this is all for naught. This is all for naught. Jim Cox is the defense raised all these points at trial. Yes, they did. They did. So, Amiott filed 2 motions to dismiss based upon speedy trial rights. The first was filed on October 16th, 2020. And then and it should have, the speedy trial clock had run by November 14th, 2019. The trial court properly denied the motion to dismiss. In that one, initially, the time was told because the original judge in Euclid recused himself from the matter. And that was proper. The judge there can't hear the case. The recusal and assignment of a visiting judge isn't a tolling, but they do consider it. The time began to run once a visiting judge was assigned on October 7th. So, 17 days passed and the clock stops. So there's now 63 days left. The arraignment was originally set for October 21st. However, the visiting judge was unable to conduct the arraignment on this date. There is a journal entry indicating the parties agreed to continue the arraignment to November 8th. Accordingly, time was told. So only 31 days had elapsed as of the appellant's arraignment. Yep. So the trial court still had 59 days remaining. The jury trial was originally scheduled for November 20th, 2019, but was continued to April 30th, 2020. On April 9th and April 30th, the trial dates were canceled. Well, and that's COVID. And everything got told at that point. Everything got postponed. They passed laws allowing courts to extend statute of limitations to speedy trial. Speedy trial got suspended in the middle of COVID, chat, just so you're aware. In January, following a number of motions, the trial was set for March 4th, 2022. The appellant did not raise any argument here or in the trial court. The time was not told between his arraignment and the March 4th date, and we declined to do so for him. So because they didn't say anything for this time frame here, the court's saying, well, you kind of waived your right to talk about that. So that means that as of March 4th, he still had 2022, he still had 59 days to go. In other words, barring any further tolling, Michael Amiott had to be tried by May 2nd, 2022. That's why you always fucking object. That's why you always object. You have to object. You have to make a record. You have to bitch and piss and moan and complain. Because if you don't, the court says you guys fucked around for 2 years. 2 years, 3 years. You see what happens? See how easy it goes? You always have to object because it looks like you're fucking around otherwise. On February 11th, the March 4th trial date was canceled. On February 16th, the trial was rescheduled for July 22nd. Appellant filed a second motion to dismiss on June 26th and asserted his speedy trial rights were violated when the trial court continued the trial from March 4th to July 22nd, with no time waiver executed by the appellant. From the record before us, there is nothing to suggest the appellant's counsel agreed to having the matter tried in July, or that appellant or his counsel was involved in setting the date. So he never agreed to that. He never agreed to that final extension. They did oppose it, and they timely objected. So now, the Court of Appeals says the city's appellate brief focuses on the motions of filings prior to the March 4th date, COVID-related delays, which it argues told the speedy trial time. The brief does not contain any arguments regarding the continuance of the March 4th date, only that it appears that the city responded to appellant's assertion his rights were violated, and they only addressed the June 26th motion. In that brief, the city referenced communications between the court and the parties regarding selection of a new date. The city alluded to an email from Amiott's attorney where counsel offered April 11th, the first week of June, as alternate trial dates. And the city argued the case was scheduled for July 22nd based upon the schedule of the defense in the court. Now, they point out, though, it must be noted that because the city did not attach the email to a brief, it's not part of the record. So, womp womp. Even if the email could constitute an agreement to move the trial, there was no speedy trial waiver executed by Michael Amiott. So even if the attorney agreed, it's Michael Amiott's right. He has to waive it. So what do? Well, Michael Amiott would normally have signed a waiver of speedy trial and executed that. So, yes. And the court's reliance on an unjournalized waiver, meaning not actually inserted and documented, is not effective. Okay? An accused waiver of his rights and statutory rights to a speedy trial must be expressed in writing or made in open court on the record. So I've had a client just do one in writing recently, and we filed it. Or they have to do it in open court. You have to do it one of two ways. The Supreme Court of Ohio has held that when sua sponte granting a continuance, the trial court must enter the order of continuance and the reasons in its entry prior to the time limits for bringing a defendant to trial. They say, for the record, it appears the court did not even enter an order canceling the dates and resetting the dates. Rather, the cancellations are just docket entries from the clerk. So the court would have to say, on this day, we decided to cancel it. Here's why we canceled it. The record does not reflect the court provided any reason for its sua sponte continuance. Remember, guys, sua sponte means of its own accord. So the court said, we're not having it this day. And they didn't explain why it was beyond the 90-day period without a time waiver. And this is actually a very true statement. You see this everywhere in America. You'll see this in a court thing. That a court record speaks only through its journal entries. And the journal entries are the docket entries that are listed and that are written out. Those journal entries on such and such date, we did X, Y, and Z. The court speaks through those and only those. The record. That's why the record is important. The record has to be preserved and protected. So, and at minimum, the trial court was required to enter the order of continuance and a reason by journal entry. But they never did. So they're saying, therefore, we find the court did not demonstrate the continuance was reasonable. Consequently, the continuance did not toll Michael Amiott speedy trial time. So we are compelled to conclude Amiott was not brought to trial within the timeline for doing so. And there's no indication that he waived his trial protections, or otherwise agreed to have the trial reset to the 22nd. His speedy trial time had long since expired. Therefore, denying the June 26 motion was a violation of his speedy trial rights, and proceeding after May 2nd, 2022 was wrong. His first assignment error is sustained. The 8 remaining assignments are moot. Appellant's conviction and sentence are vacated. It is ordered the appellant recover from appellee's fees, costs, herein taxed. The court finds there are reasonable grounds for the appeal. And there's a special mandate to issue out of this court direct on the Euclid Municipal Court to carry this judgment into execution, and signed by these judges. Bam and bam. Complete concurrence. 3-0. He gets his money back. Yes. He gets all his money back. Yes, he gets the fine money back. He gets the court costs back. He gets any fines and fees for probation back. Yeah. So Michael Amiott, his case is thrown out. Conviction vacated. So the trial was all for naught. The trial was already dead before it even happened. The trial was a nullity. It didn't matter. No, you don't get interest. Sorry. Tim Toole says they should make Hubbard pay the settlement money back. Well, that doesn't change anything there, but I thought he was only fined like $1,000. You want to give up $1,000? That's a lot of money. That's a lot of freaking money, man. I don't just have $1,000 to burn. So Hubbard got money in a different suit, right? Hubbard got $450,000. So he gets his $1,000 fine back. He gets the court costs back because he has to pay court costs. He had to probably pay a fee for probation. He gets that all back. Do you think this would have happened if the defendant was Hubbard? Well, no, Hubbard would have got charged with felony assault on a police officer. So Hubbard would have gone downtown for common pleas court. Brad says $450K of my money. I don't live in Euclid. I'm not going to tell you where I live, but I don't live in the city of Euclid, so I don't care. So, does he get his job back? Well, he was reinstated. So, and there is an update on this here. So, if you guys want to see it here, we will go to it. And this is this is the local channel here in Cleveland, WKYC. So, they point out that his conviction was overturned. After the traffic stop, Amiott was suspended for 45 days. And then after that, he was fired from the police department. An independent arbitrator reinstated him in 2018. Amiott was arrested and charged in Euclid Municipal Court in 2019 after further investigation. Remember, Hubbard filed charges, and then the whole case kicked off. Months after Amiott was found guilty by the jury, the judge announced a 90-day sentence, which was then suspended. After his reinstatement, he was assigned to the Euclid Police Department's warrant unit. Amiott said in a statement to the court during his 2023 sentencing hearing, he wasn't an advocate for or against the use of force. He said, everything I did was on my training and experience. And Hubbard received a $450,000 settlement from Euclid. Now, he was subjected to separate excessive force complaints prior to the incident. And as they talked about with Mentor, Ohio, he was forced to resign from the Mentor, Ohio Police Department before taking the job in Euclid. So, yeah. He was forced to resign. He resigned from the Metro Ohio Police Department for issues regarding not necessarily being straight with them during an investigation. So he already had some issues. And Mentor is one of the next suburbs over. It's actually not the next one over, but it's like a 10-minute drive in a car and you're in Mentor. So So, yeah. Like I said, I don't think Amiott should have been guilty, but yeah. I don't think he should have. I don't think he should have. Bella says white cops shouldn't police black areas. Well, it's like a 60% black community, so yeah. Jim says his mentor in Ashtabula County. No. Is Amiott on a Brady list for lying? I don't know. I think because it's an internal disciplinary thing, I don't think so. Is the guy who shot him with the taser getting more training? I'm sure, but I think they probably just told him, don't fucking tase when there are people like your buddy's holding the guy anyway. Hold on here. You guys are worried about Euclid's demographics. Okay. If we're going to do this, I guess we'll talk about it. Okay. So Euclid's in Cuyahoga County, Ohio, all right? It's on Lake Erie. It's got 50,000 people as of 2022. 49,600. So where is also, yes, this is a very interesting case here. Euclid v. Ambler Realty Company. This is what the Supreme Court in 1926 said zoning laws are valid. That is an actual case where it allowed things to happen. So if you guys hate zoning laws, this is the Supreme Court case that made them valid. Came here out of Euclid. So demographics, yeah. So, as of, hold on here. What is this? Okay. So, I mean, so here's the population. Here's the population. So the white population in 2000 was 34,000. By 2020, 20,000 people, white people had left. It went from being 65% white to 30% white in 2020. And it went being 30% black in the year 2000 to being 60% black. So, yeah. Yep. Yeah. Where'd all the white people go? Ohio has zoning laws. Ohio has zoning laws. Now, where did all the white people go? Well, that's easy answer. So where did they all go? Well, this is oh, we're not going to get this here. Hold on. We got to back out, chat. All right, chat. This is the state of Ohio, okay? Where did they all go? Well, they went a couple places, and it all involves not here. So this is Cleveland, okay? Oh, we gotta back out. I gotta back out of here because the damn won't let me. Okay. Here's the map of Cleveland, okay? And this is where Cleveland and Euclid and all these places are. So where did people go? Well, they went 2 different places. A bunch of them went to... Hold on. Damn it. All right, here's a map of Cleveland, or here's your map of Ohio. Somebody was asking, is Mentor in Ashtabula County? No, this is Ashtabula County right here. Euclid is right here. So where did everybody go? They all went to Lake County. Or they all went to Geauga County. That's where they pretty much all went. They all went there or there. So that's where everybody went. Where is... And like Lake County, for example, its demographics are... the demographics of Lake County are 84% white, 4% black. So there's a big difference in Lake County. And then Geauga County is... Where is... Geauga County is... What are its demographics? Its demographics are Geauga County, Ohio, that one right below it, chat, is 97% white. And it's 100,000. Both these counties are about 100,000 people. This one and this one are both 100,000 people. And this is 97% white. And this is 84. So guess where everybody went? Guess where everyone went? Yeah. Sean was there in the 97. No Geauga's there. Yeah. Those numbers are passing grades. Yeah. Pretty much everybody went to those places. So that's the area there. So, yeah, 97 who white. Sean probably lives in one of those big old fancy 2-bedroom, 1.5 bath with a front yard houses. Most houses have front yards. Just saying. Check Lake County's crime rate. Overall, it's not bad. Yes, I do live in Lake County. I've made that clear before. Andy says, I'm in Summit County. You are a brave person. KRM says they gave up on the waterfront properties. Oh, no. There are some like, oh no, the fucking lakefront houses, like lakefront properties here, like $500,000-$600,000. You get to Cleveland, they're multi-million-dollar lakefront houses. So no, lakefront homes are still fucking expensive. Expensive as fuck. What? Yeah. Yeah, they're very expensive lake homes. Also, real quick, I know people are wondering why is Jefferson County not having the county seat of Jefferson? I don't know. That's kind of weird because we normally don't do that in Ohio. Like the other counties, if they have a name, they have the name. So, also here's Springfield. If you guys are wondering where all the cats are being eaten, there's Springfield, Ohio, right here. So there you go. Yeah, and that's kind of where we are. I must live in Lake County. I do. Some of those counties are probably just farms, though. Well, yeah, most like Geauga County is basically outside of Chardon is basically people living out in the middle of nowhere. Outside of Chardon, it's a lot of Amish people, and then a lot of people it's bedroom communities. People go into Cleveland. People go to Akron because that's where most of the people live, work. A lot of people, it's a lot of bedroom communities of people living out in the country because they want to. But yeah, outside of a couple of counties here, most of these counties are rural. I mean, really, like outside of that's not a good color. Most of these counties are rural. That goes for most of Ohio. This is Youngstown. This is Canton. This is pretty urbanized. Akron, Cleveland, part of this county, part of this county, part of this county, where Toledo is, part of this county. Then you have like Franklin County where Columbus is. Delaware is very urbanized. And then you have like Hamilton County and like Butler County and Warren County. Other than that, chat, those are like the big cities. Everything else here is basically nothing. There's not a lot of people around. It's very rural for the most part. I even have a basement. Jared says, I'm moving to the 97% with Sean. Geauga County is expensive to live in because everybody wants to go there. Everyone wants to live in Geauga County. Icebread says, I'm in Franklin County. Well, I'm sorry to hear that, man. Maddie says 500K. Well, that's actually, well, those are for like the lower end houses. Like you're going to find like probably 800,000-900,000 for a decent, like a lake house that's all set up. 500 is not an expensive house. For Ohio, it's fucking expensive. That's an expensive house in Ohio. Well, hey, some of those beat the shit ones are like 5. What? Like the one in Lorraine was beat to shit. Anyways, my house is 900K and I live 6 miles from the lake. Oh, well, I don't know where you live, Maddie. I need to move to Lake County. It's not bad. 500K is a cheap piece of shit in California. Yeah. Pickaway County is a weird name. Yeah. Yep. There's a lot of weird county names in Ohio. Mr. Sniper says, my county is 8.5% black. Well, there you go. Yes, there is a Licking County. You just saw that? There is a Licking County, yes. Yes, there is a Licking County, Ohio. There is. And if you guys are ever wondering about Chili DeCastro when he got in trouble, this down here, Lawrence County on the tip, this is where Ironton is. So that's where Chili DeCastro got arrested and run out of. But yes, that's Licking County, Ohio. So. WG Phil saying, is it true to the pet nappings or it's false? It's still like somewhat being done. It's being done, but I don't know. Like I think some happened, but not as much as people are alleging. Maddie says, move to Ann Arbor. It's 100% white if they aren't on the football team. Yeah, but then you got to deal with all the commies in Ann Arbor. So SB Seller says, where are the college towns? Well, you got Bowling Green's one of the college towns. Toledo's a college town. Cleveland's got a college in it. Then there's Kent State, and it's like over here. Akron. Obviously Ohio State, Cincinnati, and all the schools down there. Yeah, you got Preble County. That's where Miami University is here in Preble County. What were you saying? Well, they're talking about like bigger ones, I think. Yeah. So like there's University of Dayton. What else is there? Youngstown State is like one of the other big ones. So yeah, those are most of the schools. Bowling Green, where I went for undergrad. And then I went to law school just up the road in Toledo. Akron is no longer a big city. It's big enough. It sounds like I'm saying jogger country with a weird accent. I understand. Iceberg says, what's wrong with Franklin County? The problem with Franklin County is all the people in Columbus. All the people in Columbus cause me fucking problems. So that's why I don't like Franklin County. Yes, there are $2 million mansions in Cleveland, yes. I live... Oh, yeah, Folsom. I forgot about that. Yeah, I forgot. Yes, I'm sorry. Yes, I forgot about that. You live over in California. I live in California. My house is just over 100K, and I'm about a 10-minute drive from a lake. Okay. Yes, there's Hocking County, yes. Licking and Hocking. Yes. There's a judge down there streams his court. I'll take a look for that. But yes, there's a Licking and Hocking County. Yes. Muskingum is also unique. Was it Hochula County? Oh, no. Actually, Simon Fairfield. Down in Lancaster. Ann Arbor is horrible. If you want to go party, it's fun. Oh, yeah, I forgot about Athens. Athens is the other school. Athens at Ohio University. I forgot about them. Ashland, yeah, but it's not a big school. Why does Ohio share county and city names with Kentucky? Well, like, if you think that's funny, if you come down here to, Belmont County, Ohio, right across the river right here is Wheeling, Ohio, or Wheeling, West Virginia. And the county that contains Wheeling is Ohio County, West Virginia. So it's really fucking weird the first time you drive over there, you get confused for a second. But yeah, this is, Kentucky down here, West Virginia up here. Case Western, yeah, that's also there. Tagged you in a Discord general, Little Crack House, almost 1 million. What? You tagged me in general. Let me see here. Where is this? Oh. Oh, wow. Oh, wow. Wow. Yeah, it didn't notify me that you tagged me. Oof. Let me see if I can open this. And people are bitching about housing prices, chat. Here you go. San Jose, California. Estimate $1 million. There's a town in Ohio called Knockemstiff. Yes, there is. So get the new airbrush working. I have not tried yet. I have not tried. And actually, how do we know this isn't a picture of the Ricada house? That shit is burnt down. Yes, it is. Porcelain Thunder says that's the value of the land. Yes. How big is the lot? Don't know. Yes, it has uranium underneath it. Google the address, see what it looks like now. All right, we'll Google this, see what we get. 1375 Bird Avenue. All right. Oh, good Lord. Oh, wow. They fixed it. They fixed it. 1375 Bird Avenue. Wow. Yeah, what's it value now, Maddie? We're gonna have to check this out right here. Let's see what Zillow says. Zillow, all right. No, we don't need the Ricator house. $1375 Bird Avenue, San Jose, California. All right, chat. So here's what we got. The Zestimate is 1.8 mil. So this is obviously, it looks like it got bulldozed, and then the next picture is this one. Ta-da! Yeah, they overpaid. Cedar Rose says tonight's a $75 million lottery. It's a lot of Canadian loonies. Can you get paid in loonies if you win? Yeah, the property tax will kill you on 800,000. In California, yeah, I can't imagine their fucking property taxes. Let's see if we can find other prior years of this. See more dates. Yeah, let's check 2018. Well, they're tearing it down. All right, so let's see the other dates. It just showed a bunch of other dates. Where did they go? All the dates are gone. Oh, there we go. August of 2019, completely gone. October 2020, they're working on it. October 2021. That took them a little while to get some money together. And they're also, I wonder if COVID slowed them down. Looks like they had some trouble with their bank getting financing. Then August of 2022, they fixed it. They made the crack house a crack home. What do they got in their garage back there? I don't know. It looks like a pretty average neighborhood, chat. Yeah, it's a very average neighborhood. It's not like very uppity or anything. They should have borrowed from PPP, yeah. Oh, their permitting was that bad? Jeez. Yeah, that's like a $300,000 house, probably. No, that was them getting the uranium out. Access, it's a minimum $1 million here. Why? It's not on stilts. It'll flood. Tim says, I think Californians might have lead poisoning. Well, of course they do. They're Californians. They're going crazy. So, all right, guys. So, yeah, that's it. The saga of Michael Amiott is over, and not exactly what you think it was. And I know a lot of you were thinking, probably, I thought he was a bad guy. I don't think he was. I think he was trying to do his job and do it the right way. So, yeah. So this week we will do Deborah Redden, the guy in Las Vegas who jumped the bench and attacked the judge. I think that'll be another interesting one. Once again, that's another non-murder-based trial. It's only 2 days long, though, so we'll try it. Going to Muskingum tomorrow. That's something people usually don't do. So, Tim says I'm moving to Iowa. Dude, land is expensive in Iowa. All the agriculture has raised the price of land, dude. So no, it's not that cheap. Dirt don't depreciate. I'm gonna learn back in the day. Dirt don't depreciate. I mean, you're looking at a couple G's per acre here in Ohio anyway, for the most part. So, That case is interesting. Thank you. Well, you're welcome. Like I said, we'll do the next one coming up. Time for a model stream tonight? I don't know. We might. We might. Move to Mississippi if you want cheap, yeah. Model stream is special guest Laura Loomer. I need a pistol at that point. So, yes, guys, if we do a modeling stream, it'll be on the on Sean's model bench. We got over 100 subs finally, so let's try to get it going. We can have fun over there. I get my airbrush going. No, I'm not messing with it this week, Chad. I've not had time. So, and it's already Friday. So, like, if I didn't get the parts that I think I've got everything I need, but I have not had a chance to mess with it, and I'm gonna mess with it on my own. So I don't know if this is gonna work. So we'll take care of it at a different time. Where's the link for my model channel? Where is it? Oh, come on. Okay, where is... Here is the channel. There's the channel. And then the airbrush Laura Loomer. Jesus. God, she's got problems, man. That's scary. Nate says 7 acres is totally worth 45. You can make a lot of money. Yeah, you can. Renting it out, but so anyways, guys, that is it for tonight. So yes, once again, the interesting saga is over. Julie said, though, Hubbard identifies as a woman. Yes, she did. Nicholas Kreuzer says for $5. He looks like several people from SNL. Yes. Nico says even Sean gets paid. Yes. Dirt Chief says, I got $100 a day to be on a jury. Lucky you with a pilot program, which probably won't last. Fatty Caddy says, we have a legal contract. You said you would get me a cutie fender's phone number. Also get bank cucksecutor. Do blacks have a right to resist now? Jesus. No comment. Agbiochema says, so objections are important. Yes, they are. And then Fatty Caddy says, lots of Hubbards moved in and the whites moved out. Yeah, pretty much. Euclid had a lot of white flight. So, yeah, so for now, it's stopped. The county line. So, all right, guys. So that is it. Thank you guys for all being here. I'm not sure what we'll get into tomorrow, but we'll get started on something, and we'll definitely probably play around with the models tomorrow night. I think tonight we're probably not. It's been a long day. I'm a little tired. Really, yeah. And yeah, do a Where's Hubbard Now stream. No, it's knocking off. You knock it off, chat. All right, guys. So remember, until next time, just because you did it doesn't mean you're guilty. And Michael Amiott, not guilty. Remember, his convictions got, so he's not guilty too. Suffer, chat. So good night, guys. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?